available. 1-8. Lordship, out of same affair, 1 AB was fixed on 2nd September. Yes. Let the matter will come on 2nd, Lordship.
Second. Yes.
Another period, Lordship, item number 33.
18 to 2nd September. She did not receive to remember.
Lordship, item number 33, Lordship. In this case, Lordship, here the petition number 2 is on interim, Lordship. CDR received. Lordship, I seek a short accommodation, Lordship, only for 2 days.
Otherwise, petitioner number 2
Two.
is on interim.
Interim.
CD receipt.
Lordship, next month, Tuesday, Lordship. Next Tuesday.
I cannot see because Tuesday some PPM matters.
What next? Otherwise, your Lordship, for the convenience.
The matters complete. 1st of September. CD received written Tuesday, 1st of September. Interim granted to the petition number 2. Be continued till next year.
May please, Lordship, therefore listing Lordship is a government employee Lordship. They have to every motion matter Lordship.
Pardon?
Petitioner is a government employee Lordship. Motion matter day after tomorrow Lordship. Published.
May I please, Your Honor? I beg to mention item number 14 with the consent of the other side.
Item number 14.
14, one,
Ah.
Your Honor. This matter may be taken after 1 week.
You have informed the NCB?
I am from NCB, Your Honor.
Oh, you are for the NCB. Oh, chacha. Okay. Mr. Dutta, NJ Dutta, and B. Ahmed Balde, have you informed them?
Yes, Your
With the consent of the other learned counsel appearing for the respondent of the NCB. 3.8 of it. Stop scan copy of the PCR has already been received. List the matter because it is a PA. Do you have any idea since when they are in custody or any idea?
Honor. No, Your Honor.
Seven, eight, nine, the date behind you. 5-9.
Please, Your Lordship, I'm mentioning for a urgent listing matter, Your Lordship. I'm for the petitioner and
You are the listing of it is BA, AB.
no motion for motion
No, it's a criminal.
bail application here.
Bail application.
Bail application, Lordship.
What kind of urgency?
Urgency for he is seeking he is so much in a
Is ill or what?
he's in jail, Lordship.
And definitely urgency is for
Urgency
everyone.
for
Is there any otherwise tomorrow or day after tomorrow may not be possible? Monday is a holiday.
Monday, day after tomorrow,
at
Your
least-
Lordship. Day after tomorrow.
Day after tomorrow, lots of matters have been already fixed. I think day after tomorrow is not possible. Maybe my Monday is also holiday. That's in that case, it will be on Tuesday only.
Tuesday.
Tuesday.
Lordship, after day after tomorrow, it will be considered for.
Day after tomorrow may not be possible. Okay, we'll try day after.
Okay, Lordship. Much love.
May please, Your Lordship. I beg to mention for listing of regular bill Lordship.
Maybe Tuesday. Tuesday.
Okay. Another fair Lordship, listing for criminal petition Lordship.
Criminal petition, you make a mention before court number 6, senior batch.
Of Blackmail.
My lord, the father of four children, my lord,
Mm.
is apprehending of arrest, my lord, on the
Arrest.
pre-arrest, my lord. Absolutely a false case, my lord. So my kindly tomorrow or day
What
after.
to do? He may be father of a 2, 3 child, 4 child.
Absolutely false case, my lord.
We have a sympathy for him.
The
But
primary it is a false.
tomorrow,
So-
day after tomorrow may not be possible. Maybe on by Tuesday. Tuesday.
Blessed.
Your Lordship, I beg to mention item number 20.
20.
20.
Hmm.
Yesterday we filed additional affidavit. So which is not which is not in the
You want to call for the
text,
additional
take it.
affidavit?
Yes.
You want any adjournment or to call for the
No.
affidavit?
Affidavit.
Oh, we'll call. Okay.
May it please your lordship. My lord, your allegation is that my lord, there was a love affair between the informant, my lord, who is 31 years of age, and the boy, my lord, who is behind the bars now, my lord, 32, my lord. They had a love affair. Admittedly, from the affair, there was a love affair. Then the relationship turned sour, my lord. Then the boy's parents, my lord, were against the relationship. And now this affair, my lord. Page 8 is the affair. May I read, my lord?
Yes.
With reference to the subject cited above, he had love relation with the above noted accused person since December 2020. Due to love relationship, we visited many places. From the year 2020 to last 2025, we have been in deep love relationship, and the accused person had made physical relation in a hotel on the pretext of marriage in the year 2020. After that, during that time, he had made physical relation several times with a false promise. When I asked him to marry immediately, then by showing different problem, he told me that he will marry me later and had maintained the relationship with ill intention. On last 2/8/25 Saturday, when we were discussing about our marriage over telephone, then the accused person gave the phone to his mother and she directly denied the marriage with his son as because they belong to different castes. The accused person informed me on the same day that he will be unable to marry if his family members did not agree. On 3/8/25, I called him and went to Hajo to meet the accused person, but at last he did not meet me. The brother of the accused person has threatened me, but admittedly there was a relationship since long. The girl is 31 years of age and the boy is 32, my lord. Now, my lord, the boy's parents, my lord, they are against their relation. Actually, this is not the actually, my lord, their relation, because there were some, my lord, misunderstanding between them because of their the checking of mobile of each other. They had a long relationship. Then relationship turned sour, and my lord, she has lost this case, my lord. And my lord, possibly, my lord, she is a major, if admittedly also, my lord, everything was consensual. She 31 years. So, my lord, further custody may not be required at this stage, my lord. He is in jail, my lord.
Otherwise, from the forwarding report, my lord, it reflects that on the pretext of marrying her, my lord.
It is in
Several
the-
occasions,
it-
my lord,
It was in the affair, sir, itself.
but fraudulently, my lord. And now, my lord, his brother of the, my lord, complainant, my lord, threatened the victim, my lord. That is also allegation, my lord.
My lord,
Not
that
only
is-
one single occasion, my lord, since although love relation is there, my lord, since earlier, but on the pretext of marrying her, my lord, in a fraudulent manner, my lord. See, my lord, he
But my
established.
further custody may not be required because, my lord,
Okay, we'll try to give a short date otherwise. Obviously, admittedly, there was a love relationship.
relationship.
That is admitted.
and she is 31, the boy is 32, my lord.
Okay, boy is 32, she is 31, but let us see the case diary otherwise.
Well,
10
case-
10
case-
days, he is in custody for 10 days.
My lord,
10
he
days, no?
is in custody since, my lord, 10/8.
Yes, for 10 days, he is in custody. Let it
My lord,
be,
further custody may not be required, your lordship, because, my lord, there was a relationship. Only when her, my lord, mother, my lord, denied their marriage, he has lost this affair, as per the affair. But this is the so father custody. Same thing will come in the case that because admittedly, my lord, we are also admitting there was a relationship on that day. There were, my lord, checking of my lord, mobile phones. Some altercation was there. She has lost this case, my lord. Otherwise, my lord, there was a relationship. Admittedly, my lord, these are admitted. So, my father keeping
this is a case from who?
Uh,
Hajo.
Hajo, my lord.
Hajo.
Oh, no.
On, my lord,
No, my lord, this is all women, my lord, all women police station.
on 4th of September, my lord, 4/9.
Court, no, give a shorter date.
1st of September.
My lord, but my lord, keeping in jail will.
Could be on 27 then.
Yes.
Keeping him in
Otherwise,
jail
my lord,
will
what-
not serve any purpose because admittedly there was.
But after, my lord, releasing from the jail, again, he will establish relationship with someone other. my lord. Again, this type of offense, my lord, he will.
My lord,
he
these
will
are his
again commit, my
speculations
lord.
and assumptions.
He
my
will be
lord.
bold and
His speculation and assumptions cannot keep a person in jail, my lord.
This type of persons, my lord.
We are listing it on 27/8.
Oblige your lord.
CD. Yes.
May I please your lordship. My lord, the petitioner was arrested on 14/6. Today is 67 days. My lord, no, sorry, 15/6, my lord. And after 10 days of his arrest, charge sheet is submitted, my lord. And now, my lord, charge also framed, my lord.
Is the charge
He is
sheet
behind
is-
the bar. After 10 days of his arrest, charge sheet is submitted.
Acha.
And FIR is, my lord, case 9. Very unfortunate FIR, my lord, because the petitioner and the informant both are own brother. And the brother lost the FIR, saying that the present petitioner assault his mother.
My lord, because victim
And
is
my-
his own mother.
And my lord, kindly turn to page 22.
But
Mother-
assaulted
mother
her
what saying
mother-
that?
Mother.
Yes,
Yes, ma'am.
victim is mother, not
And my
only.
lord, very unfortunate case, my lord. Page 22, my lord. What, my lord, mother saying, my lord? Page
Page?
22, my lord, third paragraph I am reading. The victim of this case has submitted the affidavit that she got injury not from accused person, rather by falling down. This petition is also accompanied by an affidavit stated to be submitted by Srimati Visitra Bokalier, that means mother, the victim of this case, in which it is stated that her younger son has falsely lodged this case against the accused person. And next, my lord, the perusal of the case record revealed that in this case, charges have been already framed against the accused person of offense punishable under section so and so, so and so. So, my lord, already 57 days, my lord, he is behind the bar. I am not submitting, my lord, on merit of this case, my lord, because both are brother and mother, and what I argue, my lord. Now, my lord, only
So mother
on that
sustained
point,
injury.
yeah, my lord.
Mother sustained injury.
Yes, mother in the affidavit saying that I have not sustained injury. And my lord, one son lost the fire and it reflect in the order sheet of that landed trial court, my lord. So I am submitting, my lord. At that, my lord, stage, my lord, further custodial integration is not required. 67 days he is behind the bar. He will face the trial, my lord. Mother also saying, my lord. So maybe for the ends of justice, allowed to go on bail. my lord.
Yes, my lord, yes, victim is the mother, my lord. That affidavit regarding is also there. But earlier also there is, but the case 23, my lord, White Learned Trial Court has rejected the fact that the victim of this case has not yet been examined as a witness of this case. Only because of that. Yes,
But otherwise, if you
Yes.
see what occurred,
yes, yes.
she is mother.
Mother. So
If
she
they can
wants to.
file a
Yes.
affidavit, then obviously
Yeah, yeah.
her evidence will be in there. Anyway,
wants
had
to,
Mr.
maybe-
Anuddin,
Mm.
the learned counsel for the petitioner, also had his report upon the learned petitioner PP appearing on behalf of the respondent. Is submitted by Mr. Muthin, learned counsel for the petitioner, that the present accused petitioner is absent. He has not committed any such offense as there is in the uh, the FIR is lodged by his own mother with the allegation that he assaulted his mother with a sharp. But from the order dated 22/7/2025, passed in session case number 136 of 2025, it reveals that the mother herself appeared before the learned session judge with an application, with an affidavit that she sustained injury only by falling over the sharp object. The further submitted that the case has already been charged and charge is already framed, and hence further custodial detention may not be necessary for the trial, for the purpose of trial. Next, Mr. Waterford, Ilana Direction PP submitted in this regard. That from the from the order passed in session case number 146/2025, it also reveals that the petition, the bail petition for the petitioner, the present petitioner was rejected on the ground that the vital witnesses are needed to be examined by the prosecution. Expert, considering the considering the submission made by learning counsel for both sides, materials available in the case record, and also considering the length of detention already undergone by the petitioner, who is in custody since 15/6/2025, I find that further custodial detention may not be accordingly. I find it is to extend the privilege. This is session judge Dibugor,
My lord, additional session judge Dibrigo.
dissatisfaction of additional session judge Dibugor. Okay, you're granted.
I would like.
May I please get it? Well, this is petitioner 483. Petitioner is behind the bar from 7/8, my lord. He is having a mobile shop, my lord, at Nongpho, near under Nongpho PS in Meghalaya. My lord, the prime accused, Nirmal Deka, was arrested in connection with the theft of the mobile. And it was he said that I have given the mobile to the shop. And currently police went there and recovered and arrested the shopkeeper, my lord. So, my lord,
Your petitioner is a shopkeeper.
a shopkeeper.
So
And he
he
also
used to
repaired the
receive
mobile
these-
also, my lord. So, my
No,
lord,
no, that means he
317
used
too,
to
there's
receive all the
recovery,
stolen mobiles.
stolen property there. But when he has deposited me mobile, he has given for repairing. And police along with with his mobile, others 5 mobile also recovered, taken away.
All are stolen.
No, not stolen. That are given by the given customer on bona fide receipt is there. Anyway, my lord, I pray for CD may be called for short date matter. 14 days already behind the bar.
Yes, what? 5, 9, 10.
Is under Boshishta PS.
No, Bosisto is all right.
Yes.
We are not under Bosisto, what many matters have been paid. 5/9 will be too long for you?
No,
5/9?
Yes.
5/9 is too long, my lord. No, too long. Maybe a 27, 28 of this month, if possible.
20? 1st of September. At best, 1st of September. 1st of September.
My lord, this is a case from Chandmari, my lord. Yes, but the accused, my lord, two accused has been arrested, my lord, on 12/8/2025. And one of the accused is not at all involved. Lordship may see the FIR is at page 14, my lord. This is a matter one shop, my lord.
Hmm.
Some boys, they went around 11 o'clock. They want to have something.
What to say? I am just near to the resident of that shop. I know the incident made better not to take this by me, I think.
Oh.
Otherwise, I'm not so on that case, but I have heard the incident. It's just near to my residence, in fact. Silpukuri, isn't it?
Silvaguri, my lord.
Yes, it's what to do. Otherwise, yes, you can proceed. I don't have any connection with this.
Yeah,
people.
that,
It's okay then. But it is the incident had happened.
I understand. But if Lordship is no connection, man, then I think.
Connection, no
Yes.
connection. So we
Man,
don't know any details.
Lordship may see the FIR at page 14, my lord, 11/8/2025.
Yes.
I would like to draw your kind attention on the matter that on 10/8/2025 at around 11 p.m. when the last point one shop at Silpukuri was about to close, shutter was about to down. I went there and asked for a wine, but on my asking, the owner came out the wine shop and used slang on me, and then I went towards my house. But due to some necessity, I had to come back towards the Silpukuri police point to buy some medicine of my mother. The owner, along with some social gunda, attacked me and beaten me grievously, for which I got bleeded and got grievous injuries to the eyebrow, head, and other part of the face. My known person somehow saved me and admitted to the hospital. The owner of the wine shop with his local gundas could have killed me if my known people did not have saved me. Now, sir, I want to take necessary action as per law necessary. Your Honor, this two accused person, the father is the second, Krishna, that is the son, and Radha. Now, Krishna is the director of the company, the wine shop, my lord, but father has no relationship, my lord. When your lordship, the inquiry, the case was registered, and lordship, we tried to give the Cross-FIR, which is at page 21, but that was not registered. But the actual fact,
Not yet raised.
not registered. Your lordship may see that FIR, page 21, my lord. This is to, may I read, my lord? This is to inform you that we are running a wine shop named the BR Combined Wine Shop situated at Navagra Road, Silpukuri, through our employees. On 10/8/2025 at around 11 p.m. after wine shop was closed, one person, namely S. Bora and Junmoni Kalita, along with two other persons came to the wine shop, that is BR Wine Combined Wine Shop, and they demanded to the shop be opened to give them liquor bottles. When the staff refused to open, they started abusing them and later started to beat the staff and also one of the director, Krishna Raj, that is the accused number one, my lord. Then our staff informed me and Mr. Ajay Raja, father of the Krishna Raja, about the incident. Mr. Ajay Raja then immediately called 100, 102, 12 and requested the police for help and requested his son Krishna Raj to leave the place, but he informed that his car is surrounded by some of people, so he couldn't move. Mr. Ajay Raja again told his son to leave the anyhow, and thereafter he managed to do so. At around 11:20 p.m., Mr. Ajay Raja reached the spot. The miscreants are still there and started abusing, pushing them, shoving them. They managed to hit them a few times before they leave the post spot. It is to mention earlier too, on many occasions, that some people tried to liquor bottle without payment from the wine shop and tried to snatch the cash. In this regard, we have complained many times with Chandmari police station and the same group of boys came to the police station and later on they made compromise by giving in writing not to come to the wine shop again or create ruckus in the vicinity of the shop. Now, Lordship, see, Annexure 3 is my dialing number, 100 and 102 when the incident took place. I called up, that is accused number 2, that is father. Father called up, and the father is the accused number 1, petitioner number 1. And then the forwarding report is at page 23, my lord. So, and the decision order is page 26. Now, my lord, at this stage, my lord, I know the lordship is very difficult. So at least, my lord, the father, who is no way connected, I am paying bail for him, and the son is there, my lord, case that he will be called for.
Yes.
Yes,
Yes, but
yes, my father may be allowed the other regarding other city.
Father has no connection, my lord. He heard the matter, he called the police also, and he was not there in the at the time of the incident, my lord.
heard Mr. J. Roddy Learned Senior Advocate assisted by,
BP Sharma.
yes, B.
BP Sharma.
BP Sharma. Counsel for the petition. Also heard Mr. P. Borrell, the learned petition, appearing on behalf of the respondent. It's an application section Swens, connection with Swens. All party is listed matter accordingly on 1 line. Further hearing this submission made by the learned counsel for the petitioner. Further heard the learned counsel for the petitioner. And it is submitted by Mr. No, sorry. Next paragraph, Mr. Roy further submitted that the present is petitioner number 2 is no way connected in the LS office. And sorry, here the petition number 1, I think, na?
Petitioner number 1.
Petitioner number 1 is no way connected in the LS office. And during the incident, he only arrived here and also tried to inform the police in regards to the incident. And thereafter, he also lodged an FIR, a Cross-FIR for the same incident. But from the FIR itself, it is seen that he is no way connected in the alleged offense. But he also got arrested in connection with this case on 13/8/2022. And considering his length, he may be released on bail. Next, Mr. Botapur also submitted in this regard that no incrementing statement is made in the FIR against the petitioner in the FIR. However, he submitted that CD may be called for the respondent number 2. So this accused petitioner number 2. In view of this, the petitioner number 1, Mr. So-and-so, is hereby allowed to go on bail for this so-and-so, dissatisfaction of so-and-so. It is satisfaction of CGM Kamrup Metro.
CGM Cup.
CGM Kamrup Metro. And the call for the case diary for the petitioner number 2. List the matter you are put 191. Otherwise, we are listing a matter on 1 line. And
But,
for the
let it be-
father, we have released on
But let it be on 25th, my lord.
20.
Monday, my lord, coming Monday. I pray, my lord, this is Chandmari only, my lord.
Monday is closed.
This is only done
Monday
by
is a
the friend
holiday,
can,
Tuesday we don't collect.
friend can telephone and get the case diary.
1/9.
Oh, Monday is holiday, is it? Let it be taken 27th, my lord.
No, no. 1/9 only. 1/9. Other one, we have released him bail, the father and the.
Sir, item number 5 and item number 40, my lord. From the supplementary,
and-
40, my lord.
Oh, তোমার demand আমার থাকতে বলে দিছে। Item number 5 and 40.
40, same case, my lord. I think about the same case. I am appearing in item 5, my lord. My learned friend is appearing in item 40. So this is a charge sheeted case, my lord. Charge sheet has been submitted under section 61(2), 3184, 3363, and 356(2), my lord. Basically, my lord,
61, 2,
61(2), my lord, 120B, criminal conspiracy.
and 31,
Then,
318.
my lord,
318.
318, my lord, cheating, my lord, equivalent of 420. Then 336, subsection 3, my lord, that is forgery, my lord, 468 earlier.
Hmm.
And 356, subsection 2, that is defamation, my lord, section 500. My lord, I am in custody for the last 78 days. Charge sheet has been submitted and cognizance has been taken. The lordship will kindly come to page
You
13,
are
which is there.
Custody for 78.
78 days, my lord.
Hmm.
Page 13 is the FIR, my lord.
Yes.
May I read, my lord? Dear sir, with due respect, it is reported that on behalf of Tata Semiconductor Assembly and Test Jagirod, I have not published any advertisement in any website or in any print media for job openings. Neither we have engaged any executive search agency or placement agency for recruitment drive or this ongoing project at TCAT Jagirod. However, some miscreants by criminal conspiracy and cheating are advertising in broad sense at Nagaon Murigaon area and offering employment at TCAT projects and collecting huge amount of money from the unemployed youth, especially from the students community. On 2nd June 2025, information was received that one individual, namely Saikul Ali of Nagaon district bearing so and so phone number and his gang members are advertising for the employment at TSAT and collecting huge amount of money by cheating from local unemployed youth of Morigaon and Nagaon area, which have also maligned the reputation of Tata groups among the society. This is a clear case of cheating and fraudulent activity. Moreover, some fake interviews and appointment letters are received at the gates of TSAT Jagirod on several instances, which are enclosed herewith for your kind reference. Most surprising fact is that the letterhead of Tata and company name used by this gang has no presence at TSAT Jagirod. So, my lord will kindly come to page 16, my lord. This is the forwarding report, my lord. This petitioner is a 22-year-old, my lord, boy, my lord, who was also one of the candidates, my lord, who had gone for the job, my lord. Now, my lord, grounds of arrest, number 2, my lord. The FI name accused person was Saikul, my lord, along with the apprehended accused, namely Tufail Ahmed, son of so-and-so, and Shakil Junaid, my lord. Shakil Junaid is the petitioner. And other 3 persons have created a WhatsApp group in which all the 6 accused persons were admin to the group. And they were providing job advertisement and appointment letters to employee in Tata Semiconductor Plant Jagirod to other members of the group. Well, this is where I come in, my lord. There was a WhatsApp group, my lord, in which I was also added, my lord. And in that WhatsApp group, some discussions pertaining to these jobs were there. Now, this petitioner before your lordship, my lord, he is a 22-year-old boy. He was also an unemployed youth, my lord. He was also in search of a job and he was also promised job. Main accused in this case, my lord, is one Tarif, my lord. He was the one who was masterminding the whole scam, my lord. And this petitioner, from this petitioner also money was taken, my lord, like from many other people. And they were added in this WhatsApp group where regular updates were given as to when and when the job opportunities will be given. So subsequently, my lord, when this scam was unearthed, since this petitioner was also in that WhatsApp group, my lord, he was also arrested. The police arrested him, my lord. All the materials and all the evidences have been collected. The charge sheet has also been submitted. Investigation is over, my lord. Cognizance has been taken. Now, these are all, my lord, magistrate tribal offences, my lord. So my humble submission is, since the investigation is already over, my lord, and offences, our maximum punishment is up to 7 years, my lord. This is not a case where, my lord, further detention is required. Whether this person had any further role to play or not, that will come out during trial, my lord. But in this case, my lord, where magistrate tribal offences and charge sheet has been submitted, at least in this case, further detention may not be necessary. In fact, in the charge sheet also, if your lordship kindly comes to page 48, my lord. Relevant portion, my lord, it page 50. Police has already collected all the materials, my lord. Prima facie evidence has been collected. They have also found out the modus operandi. All the fake appointment letters and everything have been seized, my lord. Bank account transactions have also been seized. So, my lord, the entire investigation is over, my lord. So there's nothing which is to be done by keeping this person in custody, my lord. Considering especially that he is a 22-year-old boy and who himself was a victim, my lord. The problem was that since he was also in that group, my lord, he also got implicated, my lord. And one of the accused persons, my lord, has still not been arrested. Summons has been issued. Charge sheet has been submitted. The court has issued summons. Now, case is fixed on 2/9. So, case will also not start, my lord, at this stage, my lord, because the other person will also have to appear, my lord. So, I respectfully submit, my lord, considering this aspect and considering the conclusion of investigation, my lord, bail may be considered, my lord.
My lord, regarding, my lord, the petition number 1 and petition number 2 in item number 40, my lord. Petitioner number 1 happens to be a lecturer of a government college, my lord. And
Petitioner number
petitioner 1 and petitioner number 2 is his brother-in-law. Brother-in-law, my lord. Now, my lord, since, my lord, the investigation has been completed, my lord, and charge sheet has been submitted before the court, my lord. And all the offences, my lord, under which, my lord, the charge sheet has been filed, my lord, are all magistrate tribal, my lord. So at this stage, my lord, I'm not going to submit on merit as to who was actually the main culprit or who was innocent, my lord. But since, my lord, they are already, my lord, in custody, and my petitioners have already completed around 76, 77 days, my lord. So at this stage, my lord, further custodial detention may not be required. Since investigation has been completed, my lord, and they are willing to contest the case, my lord. And petition number 1, my lord, he is a lecturer of a college, my lord, and
Being a lecturer of the college, he is involved in such.
he
offense.
became a victim, my lord. My lord, what happened was that the petitioner number 2, my lord, he was an unemployed youth in his family, my lord. And the petitioner number 1 thought that if he could secure a job for the petitioner number 2 and some others in his family, my lord, then, my lord, accordingly, he made a request to all these persons as to if they are willing to take up jobs or not. And he was introduced to one person called Tarif, who identified himself as an engineer in Tata Semiconductor facility, my lord. So he also got carried away and he thought that if he could secure some jobs for these people, the unemployed youth, my lord. So accordingly, he liaisoned between these two persons, my lord, the petition number 1, 2 and this Tarif. And accordingly, perhaps, my lord, he was also a victim of the circumstances, my lord, and he also, my lord, got involved, entangled in this offense, my lord. So other than that, my lord, perhaps, my lord, there are no such allegations against him, my lord. So my only submission is that, my lord, investigation has been completed. All are magistrate tribal offences, my lord, and they are willing to contest the trial, my lord. And one more accused is absconding, my lord. It is not known when he will be appearing. So, my lord, that is also one reason, my lord, for
Submission of the, my lord, correctness of the, my lord, contention, my lord, it can be only revealed by the CD. But the search sheet itself, my lord, if you lordship look into page 50, the bank account of the, my lord, accused, my lord, in the,
By
from the
page 50.
bank account,
50.
the 50, my lord.
In which item 50?
Item number, my lord, 5.
Item number 5. Those
My
bank
lord,
accounts means.
True, modus operandi, the accused person through various means, including online and offline through and so, or induce indecent people and huge amounts of money by promising job at through and so. Take document, bank account transaction. Bank account transaction statement reveal substantial money transaction made by the victims to the accused person account supporting the alias of cheating. If the persons, my lord, the petitioners are receiving, my lord, huge amount, my lord, that it reveals from the search sheet, my lord.
Whose bank accounts have been seized here?
Victim, my lord, accused person created, accused persons created bank account and provided fake appointment letters, interview letters, and joining letters of the victims. Bank account transaction statement revealed substantial money transaction made by the victims to the accused persons accounts. So, my lord, lordship, at this stage, CD may be called for, my lord, and CD will reveal whether the person who is a student, my lord,
So
whether he
bank
has,
accounts of all the accused persons were seized
My-
already.
my lord. No, but the petitioners, my lord, the
From the-
accused persons, my lord.
From this page,
So, my
matter,
lord,
it is
CD
not
may be
know
called for at this stage, my lord.
whether these accused persons are the petitioners or not, my.
CD will reveal all these things, sir. And if
These accused
those
petitioners
persons are
have made
involved in
mistake, I
the
think.
creating,
Like,
my lord,
I mean-
fake documents, fake appointment letters, it is required to be prohibited, my lord. So that this type of incidents is not happening in again, my lord, repeating again. Collection of money through deceit, online, offline mode in both.
Sakil. Yes, all these are involved.
My lord.
Yes.
My lord. So at this stage, my lord, without perusing CD, my lord,
Yes,
since
yes,
releasing
copy
the my lord,
is-
in a
Can
basic-
copy of it this year.
my lord.
But since, my lord, my submission will be, my lord, since, my lord, investigation is already over. My lord, whatever materials needed to be collected by the IO, he has collected, my lord, and submitted before the court. Now the court at this stage will only see whether, my lord, the continuing detention of the accused persons are necessary for trial or not. Whether there is any chance for them to abscond, whether there is any chance for them to hamper or tamper with the prosecution evidence, my lord. At this stage, my lord, the court will not go as to whether the materials submitted by the IO are correct or not. At this stage, the court will only be requiring the presence of the accused persons in the trial, my lord. So regarding that, my lord, we undertake, my lord, to appear, and since, my lord, these are, my lord, the local persons of Nogao, they have having, my lord, permanent address, my lord. So, my lord, we undertake to appear before the trial court,
Yes,
my
in
lord,
that
on each and
context,
every
do you want to
date, my lord.
submit anything?
My lord.
In that context, do you want to submit anything?
My lord, the theory of punishment, my lord, only recurring, my lord, to prevent all those things in future, my lord, that detention is required, my lord, so that it may not recur again, my lord. So, my lord, that only by mere presence in the facing the trial, my lord, is not sufficient, my lord, to prevent all those things, my lord. My lord, only whether the involvement of the petitioner before releasing them bail, my lord, involvement of the, my lord, petitioner is required to be ascertained, my lord, at what is the instances and what is the how much their involvement is there. If a, my lord, professor, assistant professor is involving in the issuance of the fake certificate,
That's
what
what
is
I
the,
am
my lord, all these
saying.
things
Being
are
a
there, my
professor,
lord.
he is.
And he is an assistant professor, and his contention is also is that his submission is there before this court, that he is licensing between the persons, my lord. If a person, assistant person, are licensing in this type of incidents, my lord, it will go a bad message to the society also, my lord. So it is required to be prevented, my lord. There is a preventive theory also that is also applicable in this case. I'm not saying about 22 years old student, my lord. Whether the old student is involved or not, my lord, what is his role, my lord? That is all only required to be ascertained before releasing him bail, my lord.
But these
My lord,
submissions,
my lord, that is my submission, my lord. At this stage, without perusing the, my lord, search sheet has been filed. What are the materials available in the search sheet? Lordship may peruse that one also, my lord, and thereafter Lordship may consider it, my lord.
well, these submissions are to be made at the fag end of the trial, my lord. When the evidences are completed, my lord, during argument stage, my lord, whether he should be sentenced or not, my lord, that will be made at the end of the trial, my lord, at the conclusion of the trial, my lord.
See, but
Yes.
he is saying that, I can understand
Yes.
your submission. Question is, Mr. Sutia is submitting that, at least, perusal of the record may be necessary, that is the only submission, I think. Otherwise, obviously, case has already been charged.
Yes, yes. And
But the
magistrate
one
tribunal.
question is this, Mr. Das, this, he being a professor, now if
Yes.
you go by the charge sheet and the bank accounts
Yes.
which have been seized, it seems
Well,
that,
that can al-
why he was
Well, that can al-
listening about these
Yes,
things
well,
and all.
That
He's a
can also be
professor.
interpreted in this way that a professor,
Mm.
why would he go to such extent
Yes.
of committing offences, my lord, of this kind, my lord, of this nature, my lord, when he has a beautiful career, my lord?
Yes, obviously.
Yes, why?
Why?
So he may also be a victim. That will be found out at the trial, my lord.
Founder at
He
the
may
trial,
also be a
I
victim,
can
my lord,
understand,
of circumstances, my lord.
but these things are there anyway.
Yes.
We just want to see the things.
Well,
Yes,
regarding
now,
item number 5, my lord. Item number 40, my lord, the professor part, my lord, your lordship will decide, my lord. With item number 5, my lord, he's a 22-year-old student, my lord, in search of a job. So he does not come from that influential strata of society that he will be in this way of swaying other people. He was a victim and he paid the money. Now, regarding the seizing of the bank account and freezing of the bank account, nothing, in fact, your lordship, the charge sheet itself is clear. No bank account of this petitioner was seized, my lord. The question of,
I have seen
yes,
this one.
question of seizure of his bank account will also not arise because he was the person who paid the money to get the job. Now, my lord, regarding preventive detention, this is not a preventive detention case, my lord. And regarding, my lord, the philosophy of deterrence, my lord, that as my learned friend has come, that comes at a time of sentencing, not now. Assuming whatever my learned friend has said is also correct, my lord. But these materials have already been collected. Now, if this, my lord, the record comes and these materials are there, my lord, are we to understand that the prosecution intends to keep them in custody for the length of the trial for this kind of offences, my lord? Because 7 years, if it go by Satinder until, my lord, in this kind of offences, if we had even appeared on summons, my lord, we would have been granted bail. That is the law. Now, for a 22-year-old boy who paid money, in respect of him, the entire investigation is over. Nothing as such, no bank account, nothing
In
has been
regards to
seized.
22 years ball, what
My
you want to
lord,
submit?
only in respect of the my lord 22 years, my lord student, my lord. And my lord, what is his involvement? If he is not involvement, there is no involvement regarding man licensing and other things are also there. From the my lord search sheet, it is not at all correct, my lord, whether any bank account, in his bank account, whether any amount has been deposited or not, my lord. So lordship on perusal only for 2-3 days, my lord, also fix on in a, so it is Jagur PS. Any
Okay,
date, my lord, it can be
very
done.
short date
I
in
have no
somehow.
objection on that, my lord. If a student is there and his involvement is no there, no bank account, nothing is there, then I have nothing to say, my lord. But on perusal of the CD and the records, my
Well,
lord,
even if my, I
that
don't
is
want to
only.
question your lordship on this point, but suppose, my lord, my involvement is there. With the state, does the state want to keep me in custody? Even if tomorrow the case diary comes and it seems that there's some involvement, my lord. At the end of the day, they have found some case. That is why they have submitted a charge sheet, my lord. Question is not that I am, if there were no material against me, they would have submitted an FR against me in respect of me. They have submitted a charge sheet, so definitely they must have found some. Our case is that we are innocent. Their case is that there is some material. They have some found material, that is why they have submitted a charge sheet. But for these kind of offences, my lord, tomorrow's material comes, will the state say that we should kept in custody till conclusion of the trial, my lord? That cannot be the law, my lord. So for this person, my lord, I am pressing your lordship, may kindly consider, my lord.
A short date may be fixed, my lord. Whether right of bail,
Okay,
my
then
lord,
Mr.
at this
Sutia is
stage.
suggesting, okay, then,
Right of bail at this stage, my lord, after filing of charge sheet, lordship may consider on that aspect also, my lord. After filing of charge sheet without perusal of the, my lord, records, my lord, and whether
Okay,
it's a
we are
right of
listing-
bail
we
at this
have,
stage, in a motion stage.
yes, otherwise, but considering all these situation and circumstances, we are listing it on, it's from Nagaon, na?
Nagaon, my lord.
Murigaon, my lord.
Sorry, Morigaon.
It is Jagirut, my lord. That is the semiconductor project, Tatas, my lord. If it is a goes a bad message,
28 of it. 28, we are listing it. Scan copy of the TCR policy.
Deeply obliged.
22-year student, I can understand, but
Yes,
I'm still not following why this professor is there.
Yes.
Being even in spite of having such a
Yes.
good career.
Yes.
And professor, we definitely we respect a professor.
Yes.
That means quite an educated person, but
Yes.
why he is involved, that is to be said. Okay.
Yes, sir.
Okay, we are listing it on 28.
Deeply obliged.
My lord, I want to go through the office note item number 36 subject to lordship function.
Office note.
Office note. There is a office note. My lord. Though it was a bail matter, but office note is there. So I am to take it, my lord.
You want any time?
No, item 36, my lord, 36.
6 months.
Office note permission logo lage.
No, to 6 or no?
6 months. What you writing?
Okay, then, no. Office note you want? Oh,
May it please your lordship. This is an application under 483, my lord. Petitioner is behind the bar since 26 July, my lord. FIR is at page 12, my lord. There is an allegation of, my lord, rash driving of scooty and assault, my lord. And there is also injury, my lord. So, my lord, your lordship may call for the CD along with the injury report, my lord.
Otherwise, it is an accident case.
My lord, no, my lord,
It is
there was no
accident.
accident, only allegation of rash and negligent driving, my lord. And there was allegation of assault, my lord.
Oh, no, but the case, why I'm asking because 1182 and 109 is also there.
My lord,
It's not a case, only accident case is not.
no,
Acha. Subsequently, the allegation, as per allegation, the assault is there.
it not. And the allegation of injury is also there, my lord. So, my lord, your lordship may call for the CD along with the injury report, my lord.
Since when he is in custody?
26 July, my lord.
Yes, when it
Well,
can.
CD, my lord. Hongagor PS.
Maybe 3rd of September. Hey, Borua. Oh, fix. There are. I is definitely broke or denied September. This one circumstances will legit 39 rupees per month. Permanent circumstance in Ukama. It will create circumstance. You will say, fine. In it, this one conflict and the own effort. Yeah. You would like it. Yeah, amount certificate for the people to pick our own. And you which one? 7.
I pray for case diary lordship at this stage. It's from Basisto lordship.
Your petition is in custody since when?
Since lordship 7-8.
7. Yes, Purva. But we are just short of these dates and all. That's why.
Any convenience to court lordship.
Vasishta?
Convenience to court.
No, no, it is from Vasishta.
Basisto lordship.
1st of September. 1st of September.
Lordship.
It is also Mr. Modi.
Similar prayer lordship.
Similar pay.
Is from, can it be on some fast if possible?
Okay, 1st of September.
Lordship. Much obliged, your lordship. Much obliged.
It is a previous bail application, my lord. My lord, charge sheeted case trial is just started, my lord. Next date fixed on my lord appearance, my lord. My lord, kindly see the page number 34, my lord. Page number 34, my lord. My lord, kindly call for the scan copy of the trial court records, my lord.
The trial court record is to come from which district?
Hatsingimari district.
Hatsingimari.
Satsamra,
South Salman. AP. No? Otherwise, your record is fixed on which date? Do you know this next date?
9 October 2025. Next date fixed for appearance.
9th of
in the
October.
trial court. Sorry.
9th.
Yes, yes.
Then let it be on 7/9. 7 of September. Scan copy of the TCR be called for STB within 7-9. Listing it on 7-9.
Oblige.
And
None appears on call for the petition. Listing matter according after 1 week. As on a date to be fixed by the registry.
Yeah, please, so the anticipatory bail application, FIR at page 10, Lordship. Petitioners all are the brothers, Lordship, in this case, all the accused petitioners. Page number 10, FIR.
FIR is at page number 10.
All the
10.
10, Lordship. This is the FIR. This is a false FIR only prohibiting the petitioners to go into their petty field, Lordship. There is nothing as such which alleged in the FIR, Lordship. No occurrence as such also. Fact is that the informant want to occupy the land of the petitioners. This is the main fact, Lordship, in this case. Petitioners are residing in a not nearby the village of this land, Lordship. Informant, the land is situated nearby the informant house, Lordship. No occurrence, nothing is such there, Lordship. Absolutely a false case only prohibiting the petitioner to go into the petty field, Lordship, for cultivating.
They are brothers and sisters.
All
Both
are
have-
brothers, Lordship.
Huh?
Petitioners all are brothers. All petitioners, there are 5 accused, Lordship.
No, they are brothers, but victim is brother, no.
Victim is not brother. There is no, nothing as such, no occurrence as such, Lordship.
Huh?
No occurrence as such, Lordship. Whatever he stated in the FIR. This is a totally false FIR. Only filing this lodged FIR, Lordship, the informant want to occupy the land of the petitioners. This is the main fact, Lordship. CD may be called, Lordship, on interim may be considered, Lordship, after medical report also may be called. Nothing is there, Lordship. Medical report may be called for along with the CD. Interim may be considered at this stage.
FIR reveals about grievous injury
Grievous
caused by the
injury.
my lord, rod, dagger, etc. my lord.
Etc.
That is the
Medical report may
allegation,
be
my
called
lord.
for,
But
Lordship.
if you go by the statement
lord.
of the FIR itself,
My lord.
it says that he was assaulted or he was stabbed with a dagger on his head.
My lord.
If
Giving it
head is there, then definitely he may not be in a position to lodge the FIR, number 1. Number 2 is that it is registered only under 1172, not on 1182.
My lord. I'm giving
That
it
is-
lordship.
You are Mr. Upadhyay?
ABT.
Huh?
ABT.
ABT,
Hawk.
ABT Hawk. আৰু
Medical
GS Kutia, the land and petition fee that PM says. Send application, sections, connection with Swinton. Next, considering the submission made by Mr. Hawk and also considering the statement made in the appended it's to extend the privilege of interim period expenses. Okay, will be under interim protection. We are calling for the case diary.
Medical report also may be.
Yes, along with the medical report we call for.
Second week of September.
Pardon?
Second week of September.
No, let it be on the bigger date, 10th of September.
10th of August.
Obliged.
I'm sorry, Lordship, regarding item 7 and 8, Lordship, it was fixed on 1st of September. Can it be on 3rd, Lordship, if possible?
Third,
Third, one, I have got some engagement, Lordship, that. can it-
both the matters on third?
About 3rd, Lord.
Okay, well, it's.
Okay. Much obliged, Lord. That I think that was.
Yeah, I mean.
May I please, Lord? Lord, it's a pre-arrest bail, Lordship, and it is a cross case, my Lord, cross-FIR. What has happened, my Lord? I am, my Lord, holding the position of vice president of an organization, my Lord, that is all Taya Home Students Union, my Lord. And my Lord, the informant, he is also a member of that organization. And we both are reside in the same campus, my Lord, at the Soy Mile office, my Lord, where my Lord, ground floor is used as an office, and I reside at the second floor and the informant reside at the third floor. Now, my Lord, in October, my Lord, in coming October, my Lord, there will be an election of the, my Lord, office bearers. And my Lord, a group of students, my Lord, the members, they wanted that I should not, my Lord, contest in the election. And in fact, my Lord, on the date, my Lord, that the informant, my Lord, he, along with some other person, my Lord, he has causing hurt on me, my Lord, and accordingly, I lost an FIR. First, your Lordship may see the FIR lost by me, my Lord. That is at page 23, my Lord. Page 23, my Lord, type copy to so and so. It is, my Lord, dated 3rd of August 25, my Lord. I, the undersigned Sri so and so, son of so and so, a permanent resident of flat number so and so, do hereby let you know that yesterday on 2/8/25 at around 11:49 p.m., when I was sitting at the parking of our head office situated at Joyanagar, Guwahati, one Biswadit Gogoi, he is the informant, my Lord, in the FIR where, my Lord, against which, my Lord, I am before your Lordship. One Mr. Biswadit Gogoi and Digonto Sangmai of our organization attacked me. The said Biswadit Gogoi hit me with a piece of granite in the back of my head. He too used a sharp knife and in that cut my left hand index finger. With the sharp knife, he also cut my left chest and in my right hand with an intention to kill me by life. He also made injury to my left abdomen. The said Gogoi also robbed me and took away rupees so and so and took a gold ring of my left middle finger. By grace of God, I do somehow escape and get myself in Agile Hospital of Jayanagar for first aid. As per advice of doctor, I too had a CT scan of my scalp. Hence, I pray your authority to take legal action. And your Lordship may see the certified copy at page 29, my Lord. Kindly see, my Lord.
Whether your FIR has been registered,
Yes, Lordship.
register number?
My Lord, it is registered as Lordship, Dispur PS case number 646 of 25. My Lord, may see the noting, my Lord, received by Dispur PS ZD entry number 26. That is important, Lordship. Page 29, my Lord. That is certified copy for my reading, Lord. That is GD entry number 26. And thereafter, my Lord, police has proceeded nothing, and my Lord, this information was forwarded to the, my Lord, said accused person, my Lord, who is the informant. And accordingly, thereafter, he lost an FIR that is at page 17, my Lord. May I read, Lordship? With due respect, I would like to state that on the last night at around 11 p.m., one deep sitting Fukon, that is my Lord petitioner, attacked me with a sharp knife and session at Jayanagar Atasu office and injured me seriously and also threatened me, and I alive as police has come, otherwise he should have shot me to death. Actually, Deep Sitting Fukon, in my absence, misbehaved with my wife and showed some absence seen and touched her with bad intention and also touched my wife in front of me, and on being objected by me, he attacked me like this. Because of my situation, dial 100 and the police arrived on time, Deep Sitting Fukon free away. Therefore, I request your honor kindly to take appropriate legal action against the miscreant so and so. This is my humble prayer. Your lordship may see at page 22, that is certified copy. My lord, it was received by Dispute PS ZD entry number 30. It was lost subsequently, lordship. After, my lord, I lost my FIR, my lord, which was registered as ZD entry number 26, my lord. He has come, my lord, and lost this, my lord, this false FIR, my lord. In fact, my lord, before that, my lord, I went to the Agile hospital, my lord. Your lordship may see the medical certificates, my lord, at page, lordship, 14, my lord, annexure 2, collie, lordship. Page 30, lordship. That is my medical report. Annexure 5, my lord. The Agile hospital. Founded by cut injury 4 in ring finger, deep cut in chest. My lord may see the photographs of my cut injuries, my lord, at page, my lord, 33. So, my lord, I got the injury. I lost an FIR, my lord, which was registered ZD entry number 26, my lord, and police has taken no actions against the, my lord, accused, my lord. And instead, my lord, thereafter, my lord, and which was an afterthought version, my lord, he has come and registered the FIR against me, my lord, which was white GD entry number 30, my lord. That was a subsequent FIR, my lord. After the incident, I went to the hospital, my lord. I took the, my lord, medical treatment, my lord. And thereafter, on the next day, my lord. However, his FIR was registered first, my lord, which was numbered as, my lord, Dispute PS case number 645 of 2025. Whereas my FIR, my lord, which was lost, my lord, earlier, my lord, that was registered as Dispute PS case number 646, my lord, of 2025. It is totally a false case, lordship. At this stage, my lord, I am, my lord, praying for your lordship for an interim protection, my lord. Otherwise, my lord, both are the office bearers of the same organization, and it is the election related, my lord. Some group of people want that I should not contest in my election, my lord. So therefore, my lord, at this stage, my lord, my humble prayer with your lordship, my lord, kindly to grant me an interim protection, lordship. I will cooperate with the investigation authority, my lord.
And the allegation of outrage the modesty of a woman is concerned, my lord. And the CD, my lord, call for, my lord.
Yes, sir, certainly your lordship will see the CD, my lord. In the meantime, my lord, my humble prayer, my lord, I may be protected, lord. That is my humble submission to your lord. So, my lord, apparently, my lord, my FIR, my lord, it was not registered. That information was passed on to, my lord, the informant. Subsequently, he came on the next day, my lord, without any explanation, my lord. This FIR was lost.
Mr. S. Setia.
Lordship.
S. Setia, Ilan petition. So, Mr. J. Sutia, Ilan edition. PPA on behalf of state an applicant sections where connection with students. So it is submitted by Mr. Setia that if present accused petitioner is innocent, he has not committed any such offense as alleged in the act. He is holding the charge of Vice President of the Central Committee of All Student Union, APASU, and if present, the informant also associated with the said organization, and the dispute arose only for the election which is scheduled to be held on October 2025. So if the informant out of the said dispute, the informant assaulted the present petition and he sustained previous injury on his person, for which he lodged an FIR in Dispute police station, which is registered by GD entry number 26 dated 3/8/2025, and accordingly Dispute PS case number 646/2025. Coming to know about the logic of FIR, the informant also lodged a cross-FIR against the present petitioner, which was entered as a GT entry number 30 of the 2020, dated 3/8/2025. But surprisingly, the FIR lodged by the informant is registered as dispute case number 645 of 2025. The informant lost the FIR with some false and concrete allegation only as a counterblast to the FIR lodged by the petitioner. However, he is ready and willing to cooperate the IU in further investigation of this case if it is granted with some interest. Next one, Mr. Sutia, the learned petitioner PP submitted in this regard that there is the allegation of outraging modesty of a woman, and hence he insisted for the case that no, the actual facts. But considering the entire submission made by learned counsel for Wilson's and the statement made in the I find it difficult to extend the privilege of interim period restraint to represent petition. They will reciprocate its dispute 645 and dispute 646 with a okay will be under interim protection. Appear before the IO and cooperate with the investigation.
Deeply applied. 15, madam.
15. We're listing it on 59, appear before the IO within 7 days.
15 September.
Deeply applied.
These anticipated applications, arising out of actually the petitioner is a resident of Nagaon and he's doing a hardware business. So he has an acquaintance with one Purno Kanta Suikia and Tanmoni Suikia. And they have developed business relationships. After development business relationship, they are doing business, but somehow there is a difference between their opinion and that the relation became stranger. So what happened on 21/7/25 at about 5:30 p.m., suddenly without any provocations, this Purnokanta Suikia and Tanmoni Suikia trespassed into the shop of the accused petitioner and threatened him with dire consequences and provoked him and abusing him and intimidating him. So suddenly, accidentally, they have a armed clash and with the armed rod struck a blow to the head of the accused petitioner and directed and threatening the petitioners that if you report this thing to the police, we will not spare your family also. So he got frightened and lodged an FIR. Accused petitioner lodged an FIR. And lodged an FIR. FIR is on no, lodge a complaint, not complaint, because the FIR has not yet been registered, my lord. Annexer 1, page 14. So he has lodged an FIR stating all these things, but police didn't register any complaint. Registered the FIR. So, my lord, what happened? Here, the petitioners on that he lodged an FIR on dated his date 7/25, 28/70/25. And after that, from 1st of August 1/8/25, he continuously goes on inquiring from the investigating officer, what is the outcome? Have you lodged an FIR? Have the FIR has been registered? Or have you arrested the accused? But suddenly, on 7/8/25, the investigation officer telephoned the petitioners, accused petitioners, that you have to, that the same person against whom the FIR has been registered, Purnakanta Sokia, has lodged a counter FIR complaint against you, and you have to appear. And from there onwards, the continuously investigating officer is harassing the petitioner. You have to appear, otherwise we will arrest you. And all those telephone conversations I've managed, my lord, between the investigating officer,
So as per you, when you lost the FIR,
my lord,
your FIR was,
28/7.
you have not mentioned any date, no?
Yes, my lord.
You have not mentioned any date.
No, their date is there, my lord. 7/25, my lord. 28/7. This is because this FR also.
No date is there.
No date mentioned. 27. We have made a statement. Well, we have made a statement that 28/7.
That is your statement, but your FIR, neither your FIR is registered, nor there is any date.
No, the FIR is not even this. That's what I'm telling you. But my lord, what happened? My submission is not
Where
that
is the FIR lodged by the informant?
my lord.
You have annexed the FIR lodged by the informant?
No, that's what I'm telling you, my lord. So that the FIR not complaint, that whatever the FIR, the police is harassing the petitioner's manner, that you come and appear, or otherwise you're affair. And my averment is on page 8, paragraph 8,
Okay,
page
then we're
7, my
calling
lord.
for the report. That means you're against you, till now, you don't have any information whether any FIR has been registered or not. So we are calling for the report.
We will call for the report, but in the meantime, some interim protection may be given, my lord.
No,
Because
we're giving a short date, very short date, we'll call for the report. Because till now, we are not in a position to say anything.
Yeah.
And the circumstances you
Yes,
bring
yes.
is not, it is not these things to give any interim protection at this stage, because.
no, not even
I
in,
don't think.
but one direction may be given, my lord. Not interpreted. Unless you don't threaten the petitioner, either you register the FIR or don't give any phone call or threatening the petitioners. Enlist the petitioners. So he is made so that he is not mentally harassed, my lord.
What?
Because, my lord, he that IO is all constantly go on repeatedly.
That's why
telephone
we
the-
are saying that we are giving a very short date, preferably maybe day after tomorrow also, if you can. Through telephonic information, you can. We're fixing it on day after tomorrow, so that if there are any cases
Yes, yes.
registered, then we will see. Okay. Heard Mr. S. Victor, the learned counsel for the petition. And also heard Mr. B. K. Sutia, the learned additional BP, appearing on behalf of state respondent. This is an application under section 482 CRP BNSS, seeking anticipatory bail, apprehending arrest by which police station? This is
Nagav Sadar PS.
Nagav Sadar Police Station. They submitted that the police from the Nagav Sadar PS is searching and harassing the present petitioners to come into the police station, stating that one, what is his name? Informant name is?
Informant name is Purnakanta Sokia. Purnakanta Sokia. Purnakanta Sokia and Tonmoni Sokia.
That one Purnakanta Sokia and Tonmoni Sokia had lodged a complaint before the police station. He further submitted it is very surprising that earlier FIR was lodged by the present petitioner for the same police station on 28/7/2025. But till date, there is no registration of the said FIR. Rather, police is harassing the present petitioner and asking to come to the police station. Next para, in view of this, that a police report be called for. The learned additional public prosecutor will take necessary steps in obtaining the police report from the concerned police station. Let the matter be listed on day after tomorrow is key by 22/7 to 22/8. We're listing it on day after tomorrow. 27/28. 26.
May I please the lordship?
May I please?
Yes.
This is regular bail application, my lord. I am behind the bar since 73 days, my lord.
What is the position? What Thakur is there? Here? City receipt? Yes.
FIR is at page number 10, my lord.
10.
May I read, my lord?
Yes.
The humble submission is that at about 1 year ago, my daughter, namely Deepali Mandal, aged about 18 years, due to love relation, eloped with the accused person, and since then, she is living with the accused person. On 8/6/2025, at about 3 a.m., my appropriate daughter committed suicide at the beam in a cloth in her living room, and I come to know the fact about 7 a.m. on the next day morning. It gets suspected the aforesaid incident was caused by the accused himself. Moreover, since long, my daughter was tortured by accused person by demanding dowry. As such, I suspected the accused person hanged my daughter after murder. So, my lord, so far as the buyer perusal of the FIR, my lord, there is no specific dowry demand. No earlier torture, my lord. I am behind the bar for since 73 days. My lord, at any condition, kindly consider the length of witness.
73 days.
73 days.
Yes, what?
My lord, here PM report is not conclusive, my lord, regarding cause of death. An allegation of, my lord, the demand of dowry, my lord, is there. Mental torture is also there. And my lord, here FIR incident occurred on, my lord, 8/6/2010, and marriage, my lord, within
1 year.
within a period of 1 year, my lord, this incident happened, my lord. And there are, my lord, a statement of the witnesses that this accused persons, my lord, mentally tortured her, and regarding demanding of dowry is also there. And on the day of the incident, before the day of the, on the previous day of the incident, my lord, your lordship may kindly peruse one independent witness, my lord. 73 days, my lord.
Perhaps investigation of the case is substantially progressed.
Yes,
Yes, PM report, my lord.
information is there.
Some hemorrhages.
I mean,
Yes,
cause
PM
of death is not there.
PM report
is-
received, not conclusive, my lord. PM reports, your lordship may kindly peruse regarding portion of lung and some hemorrhages. There is some. Internal, some internal hemorrhages is also lung. And
Otherwise, this was non-continuous like trauma.
Yes, ma'am.
But after dissection, there are some, I don't know, but medical terms are there, but the cause of death is yet to be assigned.
Yes. my lord, okay.
So what do you want to submit? There are some materials.
Yeah.
There are some materials, it cannot be denied, but
Yes.
can it be called for or maybe disposed of? Or anything you want to submit?
Otherwise, my lord,
Obviously,
from
they
the
did-
statement of complainant, the demand of dowry is also there.
Yes.
Regarding torture is also, my lord. And one is independent witness, that is my lord neighbor, my lord. Regarding that
In that
untoward
night also,
incident.
there was a
Your lordship may fix any sort that I will try, if my lord, regarding any cause, if I can get, my lord. On second of, I will try to get it through WhatsApp also, my lord, if regarding.
But in that case, you want to retain it or want to send it back?
I will retain the CD and will. If possible.
For Mr. K. Paraman, the Danet counsel for the petition, for Mr. P. Board, the Danet additional PP, become the apostate. Next by is submitted by Mr. Board to the city received, which also reveals sufficient implementing material that can be presented with petitioner. However, the cause of date is yet to be ascertained, and as the report of FSL is not importantly submitted that the IMAB directed on is the report of the FSL report if already considering the submission made by Planet Additional BP, let the CDP detain till next date of listing, and I will verify, and the additional PP will make direct communication with the IO. Will make direct communication with the IO to get the FSL report if already collected by the estimator accordingly. He is behind the bar since the 73 days. So
73 days.
yes, 73 days.
On,
Can we-
on the 27 or 28?
27. 27.
Highly obliged.
You're going to retain the case diary?
Yes, ma'am. Yes.
Seven and
16 TCR not yet received, ma'am. Earlier scan copy of the TCR content.
Lordship, 282 days behind the bars, Lordship. A short date may be given.
TCR not. You remember, if you will do the need. Yes. This has to come from which district?
Kokrajhar.
Kokrajhar. Fifth of September.
Can it be lower than that, ma'am? Lordship.
It will be on third. That part we cannot.
Deeply obliged, Lordship.
Okay.
17 case diary received, ma'am.
So basically, the allegation regarding lordship theft and the petitioner before your lordship is a scrap shop owner lordship. From their lordship, the some belongings were recovered. That is the case, and for that, I am 28 days behind the bar. Batteries of e-rickshaw. The allegation is the theft of batteries of e-rickshaw, and some of the batteries were recovered from my scrap shop.
Yes, well, total, he is the scrap shop owner. From his, my lord, scrap shop, total 31 numbers of batteries were recovered. And my lord, earlier also the present petitioner is involved in, my lord, similar kind of offense, my lord. One Kolgosia PS case number 34/24.
That is there in the forwarding report, Lordship. Like that was stolen that scrap normally, Lordship, the
He's
thing
a habitual offender.
cannot be said habitual offender, Lordship. Some stolen article recovered from his scrap shop. They normally the scrap materials were purchased by this scrap shop, Lordship. Sometimes it happens, Lordship. It's not, it cannot be said that habitual. Once it's a such experience that happened and this time this battery is lost.
These are batteries.
These are not new, Lordship. They're the used batteries, Lord. Used things are received by the scrap shop, Lordship.
Not used batteries, my lord. Those were stolen from the houses of. My
No,
lord,
no,
lordship.
e-rickshaw allegation to
Yes, allegation is-
E-rickshaw feed with a used battery, it's not seal packed one. It's a used battery.
Your lordship may kindly peruse the FIR on the same day, my lord, from the 4 households, my lord, from 4.
But that persons are different, Lordship. I'm not in that, Lordship. Stealing, I'm not there, Lordship. I only purchase it, Lordship. I'm being a.
Because purchaser
scrap
is there,
shop
so that's why, my lord, all these,
And
my lord.
for the 28 days, Lordship, what I had in my shop, everything has been seized by the police. And nothing now remain, Lordship. I'm a local person of the any point of time. For sake of investigation, I'll cooperate with the investigating agency, Lordship. 28 days.
My lord, these purchasers were not there, my lord, where from they will get the market, my lord. Otherwise, my lord, they would have not, my lord, stolen those batteries or these type of items, my lord. Only because a market, that is, my lord, shop, my lord, this shop owner is there, and therefore immediately after stealing those, my lord, batteries, immediately handed over those, my lord, batteries to this, my lord, scrap owner.
Rightly or wrongly, Lordship, it is a shop, Lordship, that said that is my fault, Lordship. For that I'm for 28 days I'm behind the bar, Lordship. And it's a licensee shop, Lordship. It is not a good down that I purchased all the stolen items and I sold it. So this is open, it is
But you
a
generally used to receive the
no, no,
stolen.
any kinds, Lordship, any kinds of scrap thing, Lordship. It is nearby roadside, Lordship. The open shop is licensee shop, Lordship. I've got a permit, Lordship, for that shop. It's not that some go down somewhere, Lordship, in a hidden place. People go and sold out there. It is not like that, Lordship. Sometimes it happen, Lordship, in most of the scrap shop, Lordship. It happens, Lordship, for the 28 days, Lordship. A local person at any point of time, Lordship, I'll make myself available for the cooperating in the investigation. 28 days, Lordship, 60 days mandatory. And I'm not in that first part, Lordship, in the stealing part, Lordship.
Mr. Botakuri's latest, and because there is a market of that
Yes.
stolen.
Yes, ma'am.
That
So
is why
it's
they.
open for all, Lordship. Not only now the seize has been recovered, so it is found to be stolen. Otherwise, Lordship is open for all, Lordship. It's a roadside shop, Lordship. It has got permit, Lordship.
No, that is okay. You
Oh.
have a roadside shop,
Oh.
you have a permit for scrap moving.
Lordship.
That is okay. That is not the disputed. The question is that as this shop as a scrap owner,
Lord.
he used to purchase these items. That's why this market of this stealing and all are there. That's why.
Not sometimes it happens, Lordship. I'm not saying that every occasion it happens, Lordship. Sometimes it happens, Lordship. Once earlier it had, Lordship. Now sometimes we get deceived, Lordship, by the customer.
Mr. Esmoni, he learned from deputies. So parties to be bought. Appearing on behalf of Jeffers. It's an application of section so is submitted by Mr. Modi that the present petition is purchased on bona fide belief, we purchased the batteries. Some batteries which were recovered from his scrap shop. He further submitted that he has a license for this scrap shop and he used to receive the used items by scrap shop. He is supposed to be behind the bus since last 28 days and some of the batteries have already recovered from his scrap shop and then further custody interrogation may not be required for the purpose of investigation. Next program, Mr. Board submitted in that 31 numbers of batteries have been recovered from the scrap shop of the present petition. Similarly, is also arrested in similar kind of offense under Polgacia PS custom 34 of 2024 at 24. Accordingly, Mr. Court submitted that present petitioner is an habitual offender and further custodial interrogation may be necessary. Interest of and submission made by and counsel for goods for recovery the stolen items and other aspects of the case to establish the period of detention already undergone by the and their further custodial interrogation may not be required for the investigation. Now, so and so go to the satisfaction of CGM Bohai. Hope you were granted with the
Bongaigaon Lordship.
CGM Bohai.
Much obliged, your Lordship, much obliged.
May it please your lordship. Lordship, this is a regular bail application.
Is that
Yes, they received them.
Regular bail application, lordship, 49 days in jail custody. This lady with her 3 years child, lordship. For the offense, lordship, committed by her husband, lordship.
No, this is a case, my lord, regarding a 70 years old lady was murdered by the caretaker, my lord. And he is the,
by the caretaker?
yes. And see, the present petitioner is the, my lord, wife of Ratul Das.
Caretaker.
She is also involved, my lord.
Now, lordship, may I read the FIR first, lordship. It is respectfully submitted that my
Charge sheet one? No, no.
no,
No,
lordship,
charge
charge sheet and not lordship. Specific allegation against husband, lordship. So for forwarding report said, lordship, she is helping her husband to disappear the evidence, lordship. If such a things is lordship, if it is a case of lordship disappearing the evidence, lordship, it will come under 238 now, lordship, earlier 201. That is bailable offense, lordship. So for my understanding, lordship, she has not committed any murder, lordship, because the forwarding report of her husband, lordship, may I place that forwarding report, lordship, is earlier also Peru's, lordship. Forwarding report of the 2-person, lordship. This landlady was killed at the instigation of her own brother's, lordship. That is the case, lordship.
What is it?
That is a lordship, the husband forwarding report. That brother's, lordship, instigation, the landlady's brother, he was arrested, lordship. He was already, lordship, confessed that, lordship, it was instigated by that landlady's brother, lordship. Now her husband did not implicate this present petitioner, lordship. No allegation of murder against this petitioner, lordship. Only disappearance of the evidence, lordship. If such, lordship, it is a bailable offense, lordship. Now 49 days, lordship, for the bailable offense, lordship, since case was registered under lordship 1031 and 332A and 329(4), lordship, house trespass, that will not come against this. They are the lordship tenant of that landlady, lordship.
For which one is house trespass? 3 to 9
329, lordship, house trespass, lordship.
and 332.
329 is the lordship, criminal trespass, and 32A is house trespass, lordship, and 103 punishment for murder, lordship. This allegation will not lie against this present petitioner, lordship.
Earlier 201 is now?
Now is 238, lordship.
Wherefrom you are saying that it is a bailable offence.
Yes, Lordship.
Wherefrom?
Two
Because
thirty-eight,
smoking
Lordship.
allowed 38 is definitely connected with the main offence.
Lordship,
It is not a case that it will become alone with the 238 or all.
Lordship, the case was not registered under 238, Lordship. It's said, Lordship.
But you are saying that it
Yes,
may be
yes,
a,
Lordship.
at
Because,
best it may be a case of 230. Yes, the submitting and it's a
yes,
the
yes, Lordship.
submitting that is a bailable offence. Is it a bailable
Because
offence?
Lordship kindly peruse Lordship 238, Lordship.
Yes, yes, I have already paid.
Yes, Lordship. There say, Lordship, if the offense, Roman A, Lordship, if the offense which he knows or believed to have been committed is punishable with death, be punished with imprisonment of either description for a time which may extend to 7 years, shall also be liable to fine. Classification of the offense according to the offense in relation to which disappearance of the evidence is caused by cause is cognizable, non-cognizable or bailable, Lordship. That is bailable, Lordship. Classification 1. Classification of the offense, Lordship. Offense may be cognizable, non-cognizable, but it's a bailable, Lordship. It says.
From classification you are saying,
Classification, Lordship.
but it doesn't say so.
Even the 338 to
otherwise. The section speaks otherwise. Anyway, yes, bottom.
Yes, my lord, case diary received, my lord, I will not go on all these, my lord, regarding whatever section is now, my lord, from the materials available on record. She is a directly, my lord, although, my lord, initially, my lord, her statement after the commission of the incident, my lord, his husband, my lord, his declaratory statement is there, confessional statement is there, how he committed, murdered the, my lord, a 70-year-old lady, wherein he, along with his wife, staying as a caretaker, and immediately after, my lord, murdering the, my lord, that lady, my lord, immediately he, my lord, came, my lord, that is, my lord, only why in his confessional statement, although initially, my lord, they were trying to both, my lord, trying to mislead the police by stating that, my lord, and how normal, my lord, after committing the incident in their state, initially, my lord, they were absolutely normal, my lord. And my lord, and from their statement, they initially, my lord, what they stated that they are not at all involved. Somebody has, my lord, killed that lady, and thereafter, at about 4 a.m. in the morning, my lord, the present petitioner, my lord, called the informant, my lord. Later on, although, my lord, there are other facts that informant is also, my lord, involved in case regarding abatement. These things are also there, but right now I'm only concerned about the present petitioner. And my lord, during investigation, my lord, thereafter, later on during custodial interrogation. So why, my lord, custodial interrogation is necessary? In this case, my lord, clearly reflects that after custodial interrogation, my lord, these accused persons, my lord, now he revealed that, my lord, he is involved, he himself, the present husband of the present petitioner, Atul Das, how he, my lord, he killed that victim on that night, my lord. Immediately thereafter, after, my lord, that is his confessional statement, that immediately after, my lord, murdering, committing the offense, he immediately informed her wife, the present petitioner. Then thereafter, my lord, how these two persons involved in concealing all these facts. And thereafter, at about 4 a.m., the present petitioner called the, my lord, informant. And then during custodial interrogation, police thereafter, my lord, all these things came out, my lord, that he is his wife, husband is the person who killed, and now also investigation is going on. He is involved along with the help for concealing that fact, concealing other material, my lord, evidences. He will also, my lord, she is also, my lord, during involved in, my lord, removing those, my lord, blood clotted, my lord, those clothes, my lord. These are the evidence, my lord, later on came out. My lord. Now, in this regard, other and during investigation, the recording of the confessional statement, extrajudicial statement is also there. The husband, that is, my lord, Atul Das, my lord, main accused number 1, my lord. He stated that he's the informant, the present informant of the case is, well, involved in abetting the present petitioner, while providing some financial help, providing his other, my lord, some other assurances of providing residence, and these are some of the assurances he abetted for commission of the offense for killing his own sister, my lord. thereafter, my lord, these are the allegations. And for saving his wife, of course, at that point of time, my lord, he stated that his wife is not at all involved. Only immediately after commission of the offense, I informed my wife that yes, I have murdered the my lord lady, and thereafter, my lord, what she has done. And regarding his, my lord, my lord, direct associate, my lord, she is a direct associate or not, that will also, my lord, regarding that aspect also, some of the forensic report yet to be received, my lord. So at this point of time, that he is only helping the, my lord, trying to my lord, conceal the facts. Only because of that this section is applicable, my lord. These arguments are not sustainable at this point of time, my lord. Not acceptable argument, my lord, at this point of time. There are materials against the present accused person. This is a heinous murder case, my lord. A 70-year-old lady was killed by the caretaker, and at that point of time, she knows everything, my lord. And there is also, my lord, later on something more may come up, that she may be directly associated with the, my lord, accused person, my lord, with his husband. Because in some places stated that in the morning hour, my lord, the, my lord, victim disease scolded her daughter. So because of that, my lord, the accused person, her husband has killed the victim lady, my lord. So these are some of the facts. So from these facts, certainly it reveals that she is a direct associate with the, my lord, with his husband in committing the offense, my lord. Some facts will come, my lord, later on, my lord. Otherwise, my lord, at this point of time, this is not a fit case for granting bail, my lord. She is in police custody
49 days.
since 49 days, my lord. There are yet some time to get, my lord, something more from the, my lord, forensic examination report.
May I submit, Lordship? So for my learned friend submission, Lordship, he said she has misled the police, Lordship. Even that mislead and misinformation, Lordship, that is also, Lordship, bailable offense. Her husband said it is the person that is the deceased brother instigate. Her husband said my wife has helping that disappearance of the evidence, Lordship. Whatever may be the Lordship, the case is murder, Lordship, 103. That is not against me, Lordship.
Let him
So
argue all
bailable
his
offense,
points, my lord.
49 days, Lordship, can it be detained, Lordship, because of that, Lordship? Because direct evidence against the Lordship, her husband, Lordship.
Let him argue all these points at the time of framing of the charge.
But because prima facie case is that, Lordship,
this point of
she is
time,
not,
he is not
Lordship,
entitled to-
take part in the murder, Lordship. Disappearance, it is a case of, Lordship, bailable offense, Lordship. If a bailable offense, Lordship, this is a right to get bail, Lordship. Rest I leave it to Lordship.
Well, at this point of time, my lord.
That cannot be at this point,
that
Lordship.
cannot be
Because of that, at this point of time, no cases, Lordship. 329 is not, sorry, 339 is not there. 330 is not
Case
there.
is registered
Sorry,
under what takes up, my lord?
239, 240,
now
neither
these are-
238 is there, Lordship. Only cases 103, Lordship, and 332 and 339, Lordship. 329 full, Lordship.
332A is also there.
But that is also bailable, Lordship, trespass. That is also bailable, Lordship.
332.
332 bailable. Trespass, house
Punishable with
trespass.
death, my lord, shall be punished with imprisonment for life. 332A.
How can it be 330, Lordship, 332A? Because they are the tenant, Lordship. They are the tenant, Lordship.
There are differences. You may be a tenant. Your I mean, access to that compound house, it's all right.
Yes, Lordship.
Whenever you want to commit any offense, that aspect has to be seen. What is your intention? Why you have trespassed? Is there any criminal intention? That is there in this case. Otherwise, you are the caretaker, and admittedly, you are the caretaker.
Yes,
But
caretaker.
why you have entered the house in
I'm not the
midnight?
caretaker. Caretaker is my husband, Lordship.
Whatever, you were
Yes.
there only. You were
I'm the wife of the caretaker, Lordship.
You
I'm
are
the wife
staying
of
in
the
the same compound with your husband, with your child.
Yes, Lordship. I'm staying with my
You
husband,
are
Lordship.
you are helping her, that lady, in doing some household work also.
Yeah,
That is
Lordship,
all right.
with the
That is
tenant,
all right.
Lordship. Yes,
On the
Lord.
day of incident, on the day of in the midnight,
Yes.
you entered the house along with your husband, or whatever.
Yes.
That entrance is not a simple house trespass. That is
Yes.
not at all a bailable offense. With a criminal intention of committing murder only you entered the house.
That is
That
lordship
is-
against the husband lordship. That is for the husband lordship, not for against this
It is
wife
it's
lordship.
not a case of bailable.
Because lordship,
Cannot be.
wife is not
Mr.
lordship
Beach
taking a active part.
He is a
Lordship.
close associate of his husband,
associate.
though he is not
How
directly
Mr.
involved in committing the offense.
Not directly involved in committing the offense lordship.
But Mr. Beach already done constitution. Mr. P. Port. Mr. Deputy. Which city receipt submitted by Mr. that the president debate and she is behind the person plus 49 days along with her 3-year-old child. In it's submitted by Mr. Chaudhary that present petition is not associated or involved in the committing the alleged murder, and only allegation allegation against her may be that she helped her in disappearing or disappearing the evidence of the murder, which may be available offense. And further, he stated that the other sections are like the other section, that is section 332A small a and 329(4) DNSS also not affected against the present petition, and being a and her husband being a caretaker of the victim, they had the access to the house and just cannot be considered as a house trespass or criminal as registered against as registered by the I. Further, he submitted that the petitioner is in behind the bar since last 49 days, and considering her length of detention also, her prayer may be considered at this stage. He further submitted that from the forwarding report of her husband also, it reveals that her involvement in committing murder is not there in the in the practice. However, she is ready and willing to extend her cooperation in the further investigation. In this case, she is granted with a privilege. Next, Mr. Waterford, Ilanet be submitted in this regard that the present accused petitioner is fully associated in committing murder of the old lady, and where they were staying as an caretaker. As caretaker, she in the night of the she informed his informant, and thereafter she helped her in disappearing all the evidence of the murder, and she is is helping her in disappearing the murder, evidence of murder, and conceal the entire the evidence. She is a direct associated and direct associate, and the her further custodial detention will be required to unearth some other facts. Mr. Waterford further submitted that initially the present petitioner and her husband had submitted that an incident had happened in the night of occurrence, wherein the old lady was being murdered by someone, but at the time of custodial interrogation only, the facts came into the light, and subsequently it has also revealed that the murder was committed with the instigation of the own brother of the deceased. Accordingly, Mr. Court submitted that some percent report, etc., are yet to be collected by the I, and hence further custodial interrogation may be necessary to unearth some more facts. Next, during the submission made by an account, I have also verified yesterday. Sorry, is that, and it reveals that the I had collected sufficient implementing materials against the present petition. though it is the allegation that her husband committed the murder, but it reveals that she is also associated in the said murder and helped her husband in disappearing, helped her husband in disappearing of the concealing all the evidence of murder in the night of occurrence itself. So considering all these aspects of the case, the grievous and nature of the offense and the circumstances under which the murder was committed, and that further custodial intervention may be necessary for the present investigation. Next, in view of this, the bail petition and the bail petition in fair trial stands to your petition stands to
At this stage, Your Worship. Public.
one affidavit was supposed to come.
My-
One affidavit.
My lord,
It has already.
my lord.
Yes.
Lord, in this case, admittedly, my lord, there was an altercation, my lord, between, there was an altercation between two groups, my lord. And the
Altercation between
altercation,
two groups.
my lord.
Acha.
And the reason behind is that, my lord, the land dispute between the two groups.
Acha.
And basically the dispute was with, in between, my lord, accused number 4 in the present case, my lord, and the, my lord, accused number 1 in the case which have been filed by the present group, my lord. So there is a counter case also. So for a time being, my lord, I would take your lordship to case number 17.
So filed an FIR.
My lord, that has also been registered. I have also annexed the copy of the FIR with this bail
So
application.
you all want to basically say that this is the land dispute
My lord,
wherein two groups are involved
my lord,
in a quarrel or.
my lord. Admittedly, there was a quarrel and injury occurred to both sides, my lord. But the dispute was, my lord, between the cousin of the present informant, my lord, and the accused number 4. That is, your lordship will find at page number.
Accused number 4 also sustained injury.
Accused number 4 also sustained some injury, my lord, and that, my lord, over
Now, from your side, who sustained injury?
from our side, my lord, one Anwar Ali and Amjad Ali, my lord. These two sustained injury. They were referred to GMCH. They went under treatment, my lord, at the GMCH. I have also annexed the medical slips and reports also, my lord. So for a moment, I would take your lordship to page number 70. The list of accused, your lordship got it, my lord. Page number 70. So accused number 4. So he got land dispute with the present cousin of the present informant, my lord. So now the page number 18, my lord, the contents of the FIR. May I read, my lord? Respectful submission of the informant is that we have been residing at a plot of land at village Aduripara, which has been under our possession since last 50 years. Since last 6 months, accused number 1 to 6 have been trying to grab 4.5 feet of land from out of the said land where we have been residing in. Suddenly on 21/7/2025 at about 1 p.m., accused number 1 to 6 hired the rest of the accused and trespassed into our house as per their pre-plan. And being armed with dao, dagger, khanti, axe, iron rod, and other sharp weapons, and having seen that, they started cutting into pieces the betel nut plants in my land. When my elder brother Shumar Ali, so this is the Shumar Ali, my lord, who is the owner of the land. So he has got the dispute with the accused number 1 in the present case, my lord. When my elder brother Shumar Ali went ahead to resist, accused number 2 steps him with khanti and injured him seriously as per direction of the accused number 1 and took him dragging to the house of the accused number 1 with an intent to kill him. When my nephew Amir Hamza, Dilwar Hussain, Azibur Rahman, my sister-in-law Zarful Nisa and Mofida Khatun went ahead to save him, the accused persons surrounded them and injured on various parts of their body by assaulting with sharp weapons and also outraged modesty of Mofida Khatun and Zarful Nisa by taking off their wearing. Having heard their scream when my nephew Mahibur Rahman, Mizanur Rahman, niece-in-law Mahfuza Khatun and sister-in-law Hasna Banu went ahead, the accused conjointly attacked them and injured them seriously so as to kill them. After hearing their alarm, the neighbors came ahead and took all of them to Santali CHC for treatment in a critical condition. And having seen the critical condition of Shumar Ali, Mufida Khatun, Zarful Nasa, Azibur Rahman, Amir Hamza, and Dilwar Hussain, the doctors referred them to GMCH for better treatment. At present,
These are
the
the
persons,
victim
my lord,
of informant side.
my lord. So, my lord, this is the basically the express allegation of causing injury, my lord, is against accused number 1. No, my lord, accused number 2, who stabbed the injury, my lord, as per the direction of accused number 1. So, specific allegation is against accused number 1 and 2, but they are not before your lordship, my lord. But so far as the other allegation is concerned, my lord, all the allegations are generally in nature. No specific imputation is there in respect of any of the petitioners, my lord. So as many as 18 persons were made accused, my lord. But out of those 18 persons, my lord, only 4 got arrested, and those 4 petitioners are before your lordship, my lord. Now, that for a moment, my lord, for perusal of the, my lord, the actual fact, your lordship will find, your lordship will come to page number 34, that is annexure 4, my lord. That is the FIR which has been lodged by the wife of the accused number 4 in this case. Page number 34 is the FIR, translated type copy, my lord. Here, that the accused number 4 in the present case has got the dispute with Shumorali, who has been made as accused number 2 in our FIR, my lord. That has also been registered, my lord. So, this may I read, my lord, the contents of the FIR, my lord. Page number 35. Respectful submission is that land related to disputes were going on with the aforesaid accused person since last 6 months ago. Regarding said disputes, on last 21/7/2025 at about 2 p.m., being armed with sharp weapons, the aforesaid accused persons trespassed into my house as per their pre-plan and started assaulting me and my husband Shahjahan Ali all on a sudden. Having heard our scream, when my family members Abdul Salam, Abdul Rafiq, Sharifuddin went ahead, the accused surrounded them and started assaulting them. Besides that, the accused entered into our house and took a sum of rupees 3 lakhs and jewelry ornaments worth of rupees 6 lakhs by breaking open the lock of the table and almirah, etc. And while they were vandalizing the household articles and destroyed various plants of our house by cutting them into pieces, while the laborers working in the field resisted them, the accused persons also assaulted them and injured them seriously. Although the injured were taken to Santali CHC for treatment, having seen the critical condition of several persons, the doctors referred them to GMCH for better treatment. Be it stated that when again at 5 p.m., they openly threatened us of death, we were absconding, leaving our house on account of being busy in the treatment of those who were seriously injured by the accused. Lodging of FIR is delayed.
Okay.
So,
Yes.
this is basically the facts. My lord, for a moment, I would take your lordship to some medical reports, my lord, that our side also sustained injury. They were also referred to GMCH. They have undergone treatment at GMCH, my lord. I have annexed them, annexure 3, that is page number 22. There are several medical slips, my lord. This is the slips and reports of one Anar Ali and Amjad Ali. They also sustained injury. They are from our side. The fact is that, my lord, the present petitioner are not the family members of the accused number 4. We are the uncle and cousin, my lord. That when we saw that the accused, the informant side, my lord, they entered, trespassed into our house, my lord, and were assaulting, my lord, the Shahjahan Ali, that is accused number 4 in the present case. That we proceeded, and in the meantime, my lord, there was a altercation between the groups. Both the sides, my lord, gathered their relatives, and and accordingly, my lord, the incident took place, my lord. I admit that the altercation took place and injuries were from both sides, my lord. But so far as the present petitioners are concerned, my lord, that there is no specific allegation against them, and that they have been, my lord, behind the bar since last 30 days, my lord. Because on 21/7/2025, they were arrested, my lord. So subject to the materials in the diary, my lord, so far as our, my lord, plea is concerned.
Yes.
Item 36 also from the same year. Item number 36.
Item number 36 AB, my lord. The present is regular.
For your lordship. Already my learned friend submission, there is a close case, my lord. In fact, my lord, both houses the adjacent, my lord. Regarding a simple, my lord,
this
Matter, there is a
medical-
dispute
medical
arose, my
related-
lord. And all the family and relatives name has been mentioned
medical,
here.
you have some medical.
Medical report is there, my.
From our
8%.
side.
No, my lord, if our side, that side, it is not, not the case, my lord. Here, we are concerned with the present case, my lord. That is 26-25, my lord.
My lord, this
That is
medical-
26-25. We are not concerned with the cross case, my lord.
Medical report, my lord, the honorary. Because number 4 of.
Here, Lordship, may kindly page the statement of the injured person.
Side, my lord, states some injuries.
That is not the ground, my lord, for bail, my lord. Both sides injured, cross case is there, that are not the ground, my lord. We are concerned with the present case, my lord, that is 26 of 25, my lord.
And already, my lord, they got the interim bail. My lord. In our close case, last occasion, the honorable court, this court, my lord, was pleased to allow the interim bail. So, my lord, for times of justice, my lord, may be allowed to go on bail. They are the neighbor, my lord. And ultimately, it will be settled and take some time because case is going on. If the honorable court, my lord, pleased to allow the bail, perhaps matter will be settled because both party, my lord, should have peacefully lived there. So adjacent neighbor, for this case, nobody can shift from the place, my lord. And somehow it is happened, my lord. And assault, my lord, both side, my lord, injury also both side, my lord. And some was minor, some major, my lord, these are happened. So, my lord, bail may be granted at this stage, my lord, for the interest of the society, my lord, because adjacent neighbor. Otherwise, the matter will go some different. And they are enjoying the interim, my lord. And we are in outside problem.
Interim.
They are also trying to harass our family member.
Yes.
My lord. Here in item number, my lord, 20, my lord. They are in bail, they are in custody for 30 days, my lord. And from the case there, matter, it reveals that, my lord, that is, although it is in the earlier occasion, it has said that sorry put in 65 years, my lord. He has the involvement, my lord, how he has hit in the head, my lord. And other accused persons are also involved in, from the statement of the, my lord, injured victim, my lord. All the persons, my lord. Here in the BA, my lord, there are 3 persons and AB also.
BA 4%.
BA 4% and AB in 3 persons. All of them involved, my lord. And Lordship may kindly page the injuries, my lord. 8% injured, my lord. Medical report, my lord. Some of the grievous injury, and some of the simple, some of the blunt objects, some of the sharp weapons, my lord. And some of the vital parts also, my lord. It is not the case that, my lord, there is a cross case, there is an altercation, there is a injured from the both sides. These are not the ground for granting bail, my lord, at this stage, my lord. And I has collected, my lord, sufficient material.
My lord, subject to the approval of your lordship, I will take your lordship to paragraph 8 of my petition.
No, don't repeat.
No,
Because, my lord,
Repetition.
my lord, may kindly bear with me for a moment, my lord. Because so far as petition number 1 is concerned, my lord. Petition number 1, he was not there, my lord, because the allegation is the conspiracy, my lord, that all the accused persons conspired and accordingly.
Yes.
No,
my
no,
lord.
here I have flagged my lord, sorry,
Perfect
put
can,
my lord.
may be very healthy to
My
commit
lord.
such kind of.
My lord, my another plea, my lord, because, my lord, I have taken the plea because we were arrested on 21/7, my lord, on the date of incident, my lord. But we were produced on 23/7/2025, my lord. So that was beyond the period of 24 hours. And for that, my lord, the police has not.
Taken that plea before the learned magistrate.
My lord,
Why have not taken this plea before the learned magistrate?
because, my lord, that plea, admittedly, that plea was not taken before the learned court.
Taken up this plea at least before the learned magistrate.
My lord, that was, I honestly admit. But the fact is that, my lord, even if it is not pleaded, my lord, but it is my constitutional right. This honorable court knows very well, and that your lordship was pleased to
And in that
grant
case,
relief on that ground, my
What
lord.
was the condition?
My lord,
At what time you got arrested?
my lord,
As per you?
my lord.
As per you?
Yes,
What is
my
the arrest memo, as per arrest memo when you produced or when
In
you
which
got
time,
arrested?
but in which
My
time?
lord, as per arrest memo, yes, kindly come to the forwarding report, my lord. That page number 20, my lord. Page number 20, date, my lord, the date, time and place of arrest. That is, formally, we have been shown to be arrested on 22/7/2025 at about 4:10 p.m. at customer PS. Milord, we were brought to the PS on the date of occurrence, and we were kept in the police lockup.
We don't have any,
My lord.
we don't have any materials before us now.
Yes, we have, my lord. If your lordship is pleased to peruse, I have, my lord, I have annexed certain documents. For a moment, your lordship may kindly peruse the same, my lord. Page number 51 onwards. My lord. Page number 51, my lord, this is the report, my lord, published in the newspaper as well as on some electronic media, my lord. If your lordship is pleased to peruse 52, my lord. Because,
Electronic media,
my lord,
they try their own case.
My lord,
Electronic media.
of course, my lord, but the fact is that, my lord, we were taken into custody, my lord, on 21 itself, my lord. We were there in the police station till the 23, we are produced, my
We
lord.
were not arrested. Maybe
My lord.
interrogation for you.
My
maybe
But
picked
whether,
up,
because your lordship,
because there was a coil, you maybe picked up for.
then in
interrogation
that case, my lord,
Only.
then in that case, my lord, I may be allowed some time, my lord, I will place,
You are not
and this
arrested,
honorable
you
court
are
also
not
knows
being arrested.
that because, my lord, formal arrest is not necessary, my lord. If my movement is, my lord, under the control of the police, my lord, officer, my lord, and that I am not allowed to move anywhere at my, as per my wish and will, my lord, then in that case, that also amounts to arrest. I will argue on that point, my lord. If your lordship, please be permit some time, my lord. And there are also some judgment also, and your lordship also was pleased to observe in several judgment in that case.
It's a bail matter, my lord.
In bail matter itself, my
If
lord.
argued
That
by
was
then
because, my lord, so far as your,
quashing of the FIR, he may come for quashing of the
no, my lord,
FIR.
I want to
And
place.
this case we may, we have fixed your
Lord.
matter at, on maybe 5th of September.
My lord, one thing.
We'll fix it on 5th of September.
My
We
lord.
don't have any.
My lord.
We don't have any other dates. We'll retain the case diary and it matter will be fixed on 5th of September.
My
Both those matters. You may argue on that.
My lord.
On 5th of September. Not, we don't have any time. The request made by the learned counsel for the petitioner. Let the matter be listed on 5/9/2025. CD can be retained till date.
My lord.
CD be retained till next day. We are listing it on 5/9.
My
lord.
Both the cases.
My lord.
Both the matter. Your one is 36.
Yes, sir. Item 30. Supplementary, item number 41.
36.
Obliged.
চাষি দিকে আসলে মুছে ওখানে রিটেন করবে 29 দেব 29
Section গুলো দেখবেন person income. I see. Well, regular bail, my lord, is in custody. Today is more than 113 days. Tax sheet file, to our information, Charles also framed to our information. Now, you know, he only might have made a share in a comment regarding some Pakistan, my lord. Page 14, your lord's country.
It's a charge sheet.
Tax sheet. Yes, Can copy was called for it if there.
So you are in custody since last?
Since my lord 29/4/25. Today is 113 days. So you kindly have a look to my lord that two part, my lord, the FIR two part. One part say that he made a comment. Other part say he made a share. Sharing, my lord. So his case is the accidentally he was seeing the real, my lord. Sometimes people touch the mobile, my lord. Accidentally it, my lord, just he did not have any intention to do anything, or he did not do make any comment at all, my lord. So only my thought one sentence, my lord, page 15, your lord, 14, my lord. FIR.
1/4.
Yes, 1/4.
Yes, 1/4.
On 28/4, one information received that one individual named so and so
But he is a vegetable seller, my lord. Ordinary man is not grocery, etc. Who supported Pakistan on Instagram. His post is sensitive, leading and potentially detrimental to unity. Details of the incident, you also kindly note. 128/425, one information has been received that one individual, namely Manwakshi present petitioner, has commented on a post by Pakistan full support in his Instagram account upon the press conference of Honorable Chief Minister, Assam CM, Nduko Peldia from his Instagram. Then my FIR says this kind of sharing depicts, first I said my comment, now sharing depicts his support during the time when the entire nation is mourning that Pahalgam incident, this post that. So I request that it is registered. Then you also Phagwani report was page 16, same thing, madam. This kind of sharing, page 16, madam, brief the facts, then thereafter you also this kind of sharing deputy support work. So sharing, madam. Main is whether comment, whether he had knowledge or not, that is only your loss to see, madam, from the record, madam. So his case is, madam, accidentally it touched that real, madam, so ultimately that was found to have shared, madam. Now, my lord, now section to information, my lord, 152 deals with endangering sovereignty and integrity of the India. It is new in BNS. It was not the idea, it was not an offense in so far IPC is concerned. Now it is an offense, my lord, and life. Minimum, my lord, 7 years and may extend to life. Minimum 7. Section 152, your lordship.
Sorry, 1152 or 11?
No, no. 152.
Oh, 1.
BNS.
Sorry.
152. Man. Explanation you all will find bottom notes. In penal code, tried to repeal act that endangering sovereignty, unity and integrity in India was not recognized an offense. Note your lordship. May extend to 7 years or life. Life is also. Then your next section is 172. Sorry, 197.1. Hate speech on religion extend to 3 years. 197.1 A, small a.
Yes.
Then 352 your loss kindness. This 3 section and 353 mistake, my 352. 52 and 53 your loss.
Yes.
Now case was registered, my lord, along with this section 197, but that charge has not been framed under those sections, fine.
Yes, in the present case, charges already framed.
Only 152, just now I have read, 152.
Charges framed under 150.
152.
Yes.
Then 1971 A small a, 352, 353. 197 not frame, my lord. Hate speech. 113 terrorist act, that also not there.
No, you're saying that 197 subsection 1 small a is framed?
197 1 small a, hated speech on the religion.
That is framed.
That is there. That is there. That's framed under this section. Now, my lord, he's not a big man, tough, my lord. Sometimes it actually happens, my lord. Nothing happened also, my lord. And this young boy, my lord, age also your loss will find hardly, my lord.
Young boy.
Yes, 22 years, my lord. So, my lord, I lift your lordship, but I think it is enough, my lord. He also learned a lesson, my lord. And he should learn a lesson. That also, I think. Even if it's accidental, he needs some sort of, my lord, this kind of things. so that others can get some message also, my lord. I think enough, my lord, 113 days, my lord. And the rest I leave to your lordship. my lord.
Lordship, sometimes their feelings come out.
No,
In some cases, their feelings come out sometimes.
Uh-huh.
Anyway, Lordship, some witnesses have been recorded in the
Already
180 statement, Lordship.
How many cases examined?
Not examine, Lordship.
Not yet started.
One,
Oh, acha.
Only charge frame
161, okay.
yesterday.
4-5 statements are there.
25.
4-5 statements are there.
Witnesses statement,
Witness,
180.
There is. Search frame, Lordship. And Lordship, kindly see and I take my Lordship. And this.
Everything seized, my lord, also. Mobiles, well, everything is seized. Also. So for the. Particular notice there. Okay. Down the way. We allow my So, please, okay.
Yeah, are there any other submission from your side?
And this was Lordship, because Lordship, I guess he has done a wrong, he's done an offense, Lordship, regarding that part, Lordship. Yes, Lordship, I leave it to Lordship. Inside that.
Okay, I'll pass the order.
Obliged to us. The next item is. Huh? Oh. But it's only 143 item, my lord, that scan copy was followed, I think it has not come. So, my lord, 43. First day is going to go, my lord, you also a short date, my lord. So the file also. Hey, Asan is. Nine.
Can copy not received.
Not received.
43.
Kundra?
It's not received.
Oh, to our information, if they already come, they informed us. My junior is saying, I'm not my lord. He is saying that already it was sent from the office, my lord. But it has not reached here.
As it is not available with the record, Lordship can pick
So
it
next
on
week,
any other along with
next
the-
week, my lord, any date one.
Scan copy of the decision. To remind the district within it. You have the information, it has already been received.
Yes, it was sent from the office, yes, he's, my junior. Next week, my date, my lord.
However, it is submitted by Mr. Dorbe that as per information. The TCR scan copy of the TCR has already been sent of the consent. In view of this, let the matter be listed. We don't have any short date. 19.
May I please hear? Lots. This is a matter of 103 actually, and I am in behind the jail for 185 days. As of 6 months, 4 days, as of right now today. So my bail was rejected by the trial court, which is in page number starting from 20, Annex D. And if your lordship would come to page number 22. 22, my bail was rejected mainly on 2 grounds actually. It is in point number 10. On the other hand, the land PP vehemently opposed the bail application by submitting that the accused and the prime witness of the case, that is the parents-in-law of the accused / parents of the deceased, resides at the place of occurrence house where the accused also resides, and the occurrence took place in the very same house, and there is every livelihood that the accused who has a violent nature will cause harm to the prime witness or threaten to do so. In here, what happened is actually the allegation is of killing of my wife actually. My parents, my in-laws actually, they are from Meghalaya, Bengalis. So we have been staying in Paltan Bazar house on higher basis. In the same house, we stay in 2 rooms, but we pay each other's rent. Now the father of the victim has stated that if I am released on bail, then I could also do some acts which they might feel bad actually. This is the point number 10. 11 is that from the contents of the bail petition, it appears that the accused does not deny having caused the death of the deceased wife. The nature of the offence is also heinous, and a trial is yet to proceed and is in the consideration opinion of this court. Having regards of the facts and circumstances of this case, it could not be safe to release the accused on bail at this stage. Now, the trial, the offence explanation, the framing of charge has been done. I have denied it. And the thing that why I had written that the act had been done from my hand in my bail application was that I surrendered myself on the same day. This was the heat of the moment which was down. There was fighting between both the two. And after I did some acts which was not in my mental state, after I saw the blood and all, I till that time did not know she was dead or alive. But immediately, the Paltan Bazar police station, in 20 minutes I had went there. My bike is still in there itself. So the thing is that because I had myself surrendered, there is no flight that I would be running from here actually. So because I have personally surrendered to the police station on the very day, morning 8:30, 20 minutes after the incident. So that's why we have.
But you originally belong from which place?
I belong from a district of Nalbari, but I have been staying in rented house since long. I am a driver actually, Uber driver. I have myself taken a loan from Cholamandalam and I am driving my car itself. So basically, I am a driver who used to run from the Paltan Bazar to Meghalaya, up and down. So there are lots of things which there is a difference between us and two. So this heated arguments went to many times. It's the thing is that, but in this present, I'm for the 185. Actually, Your Honor, what happened is I have already filed one bail application here itself, High Court. In the 89th day, the land people also here. On the 89th day, we came to know that that charges has been filed. So we have been asked to move to the trial court. When we moved to trial court, it took us another 1 month time because search sheet was done. but the POC number was not done. Then we have to wait for another 1 month's time. And when the matter came for hearing, then it came to know that from the CGM, the file came to session judge, and we had filed it to the assistant judge. So from there, we again withdrawn it. Then when we on the date where the charge framing was done, we had filed our bail application. On the same date, the informant also filed his objection regarding this one, that I should not be allowed to go on bail. But your honor would not come to know from here actually, but he has filed. And on the basis of these two actually, on the basis of these 2 points, even after I have been languishing in jail for 185 days, I have been denied the bail. I could not go into merits of this case and like this. I could just only say that punishment has already been given to me from the 6 months, 4 days. And my bailer, everything is from here. I stay here actually. So I'm on the flight risk because I personally went to the this one. I personally had surrendered myself.
Oh, yes. So here in this case, Lordship, total 18 witnesses has been listed as in the search report. And out of them, none of the witnesses is being now till late now examined, Lordship. So Lordship, and case is in seriousness, Lordship, 103 is added in this section, 103 is dear Lordship. And regarding the heat of the moment I killed him, that may not be a ground for seeking bail. And that also that he himself has appeared before the IO and surrendered, that also may not be a ground, because at that time because he had no option, he knew it definitely that he otherwise there is no option escaping from the police, Lordship. So he had surrendered. And till that, Lordship, there are 18 witnesses and persons who can kill his wife in such a way. Lordship, will see the postmortem report, Lordship. He hit his wife in the head with a rod. All these are their Lordship. So Lordship, when person can hit kill his own wife in such a way, so he can influence he can hamper or temper the witnesses, or he can be the threat for the witnesses also, Lordship. So at this stage, Lordship, when there is the section 1031 is here in the section in the search frame, during search framing, it has been search has been framed under section 103. At this stage, Lordship, the bail may not be granted, Lordship, because Lordship, and witnesses have when the statement of the witnesses 180 statements are there, they have specifically admitted, Lordship. 180 statements is there, or one of a person who has been 180 statement whose statement has been recorded as Lordship that he was present at the time. Definitely, he has not denied that. Actually, he has not denied the incident. So, Lordship, at this stage, Lordship, when no witnesses has been examined, and case is in heinous nature, above this, probably there is no such heinous offense. It is the topmost heinous offense, we have to say. So, Lordship, at this stage, Lordship, bail may not be granted,
Lordship,
yeah, for the informant.
And also the petition filed, my lord, I do not have the copy of the petition of this honorable court, because I have not been served with a copy. My lordship, when it was filed before the honorable session judge, my lordship, there was a paragraph which I'd like to read, lordship, that has been quoted. The accused states that in the early hours of 16 February, my lordship.
Which para?
My lordship, this was the present
This
petition
is the
filed.
order.
My
You are
lordship,
reading
the
from where?
order, no, my lordship, this was the petition that was filed by the accused before the session starts.
Oh,
Because
okay.
I would just read one paragraph of that petition. The accused states that in the early hours of 16 February 2025.
Lordship, 7 number, same thing. Point number.
I'm not having this.
7 number, page number 8. Same thing.
A heated verbal altercation erupted between him and the deceased, which soon escalated into a physical confrontation. In the course of the scuffle and in the state of emotional turmoil, the accused claims he unintentionally picked up an object in his hand and struck the deceased without realizing the severity of his actions. It was only after a few minutes of silence that he noticed that she was bleeding and had collapsed into the bed. Shocked and panicked, the accused states that he could not initially comprehend the gravity of the situation. After approximately 10 minutes realizing what he had occurred, he immediately took his bike and voluntarily proceeded to the Polton Bazaar police station to report the incident. My lordship, there was another, since we are served with the copy, I'd go to the, in the next room, the mother and the father of the victim was also there. The small house in the small rent. They were there when he opened the door. The father asked him, anything wrong? He didn't say anything. He went back. Thereafter, the police came along with him and they have searched the weapon of offense and they have seized. They were always having shuffle between them. He used to beat her every there and then in the public itself, everywhere. That night, he killed her. The baby, who was only 2 years old, was besides them. And that child is with the grandparents now. The emotional turmoil of the family. They could not save their daughter who was in the next room. They were unaware. He came out. Had he told them at that moment also, something could have been done. Might. So, my lord, this is not a case where lordship may be privileged, this benefit should be given. And my lordship, the charge was framed on last, it's fixed day after tomorrow, but as the, my lordship is aware that its honorable session judge has been elevated here, my lordship, since there is not recruitment, new posting has been granted, so my day after tomorrow, it may not be there, but at this stage, no witnesses have been examined. So this is not a case where the benefit or privilege should be granted. And with regard to 6 months or something, after all, it is a case where life imprisonment, it may be converted to furthermore also. So, my lord, this is not a case where, my lordship, the benefits should be granted at this stage.
Lordship, in this regard, which I want to say that that going to the police station to surrender myself is not a crime. There are lots of murders are going on. They never go there. I went there. I have stated everything. And the colors of the victim also, I could not to bring in the light of this court, the petition, the court can go through it. She had also not cover, I mean, the character, I could not like to speak about the victim because of her character and this one, always the fight was going on. Always the fight was going on. And if
There cannot be a ground.
Regarding
No.
character, nothing is there. I have not found anything regarding character.
no, if you could want the paragraph to be read, I could.
Paragraph is
read it
something
here
that is
itself.
defense, but
Yeah,
at
but-
this stage, we are,
He is
Yeah.
he is in jail. He is in jail. Now who will give the statement to this? It is in his mobile phone which has seized it. There are some video clips which my client says I went to jail. There are some video clips and everything. But why I am praying to this that this all will come in the matter of trial. This is simply a bail application which I have applied. My incarnation is of 6 months, 4 days as of right now. Investigation done, charge sheet done, everything done. And if I'm released on bail, why will I go and stay with my father-in-law in that same house? Why? I will never go. Or if the court gives any of the such directions, that will also be looked after.
Heard Mr. I.S. Mujumdar, United Council for the Petition. Also heard Mr. E.S. Crawford, Internet Christian PP, appearing on behalf of State Council, and M.S. H. Burma, Internet Council, appearing for the An application under section 7, connecting with CDBC. Next, is submitted by Mr. Mujumdar, the representative petition. It's behind the bars since past 6 months. And the case has already been charged. The charge has already, and charge is also framed against the petition. He further submitted that out of the heat of the moment, after a heated argument, he committed the offense. And thereafter, on the day of incident itself, he surrendered before the police station. And since then, he is in custody. Thus, there is no chance of he will appear before the station just on each and every date to be fixed. He further submitted that his earlier bail application was rejected by the learned session judge only on the two grounds, only on the grounds that that the parents-in-law of the accused also resides in the same house, and thus there is every likelihood that the accused who is violent in nature will cause harm to the prime witnesses or threaten to do so. In view of this aspect and considering this aspect and the gravity of the offense, his earlier bail application was rejected by the land decision. He further submitted that the house wherein he was residing in one room and was residing in one room on rent, and on the other room his parents-in-law who were residing. But it may not be a case that he will again reside in the same house along with his parents-in-law. Next one. Mr. Lockwood, Learned PP submitted in this that the cases of submitted that 18 numbers of witnesses are listed by the witness with 18 numbers of witnesses are being cited in the charge sheet. Until that no witnesses could be examined by the prosecution, only charge is framed against the petition under section 103 DNS. He further submitted that he committed the murder in the next room and in presence of his parents-in-law and other persons, and hence probability of threatening or tampering with the evidence of divided witnesses also cannot be denied at this stage. Accordingly, his objection submitted that a bail petition, the present petition, bail petition may not be considered at this stage.
No.
Next one. Ms. Borba, the learned counsel, apparently submitted that the accused had committed a murder, which is also admitted by present accused, and he even after the incident, he did not inform his parents-in-law.
My lordship, her parents actually.
Sorry, her parents.
Because they are living together. The victim
Oh,
parent, yes, my
his
lordship.
father.
His father-in-law and mother-in-law, her parents.
I mean,
Victim
I am
parents.
saying parents-in-law.
Oh, my lordship, my lordship.
His parents-in-law and leaving his wife in such a situation, he went to the police station and surrendered himself as there was no other option. But from the entire circumstances, but from the all considering all the circumstances of this case, there is every probability of tampering or threatening the vital witnesses, and accordingly, we submitted that bail prayer of present petition. Available to consider stage. Next. During this submission made by the names of both sides, I have also verified this record. Scan copy of this thing. And this same that his bail application was presented by learned session judge with the observation of probability of tampering with the vital witnesses, as there was submission from the informant side that the present petitioner may threaten or do something or may cause hurt, etc. to the parents-in-law who are the vital witnesses of the prosecution. So considering this aspect of the matter, the nature of offense, and also considering the fact that the prosecution, the trial is yet to be commenced and the vital witnesses are yet to be examined by the prosecution, I find that I do not find it proper to allow the accused petitioner to go. Same solution. Your petition stands rejected at this stage.
Obliged, my lordship.
21, what is the?
My lord, here, CD, up to the CD call for minor, that was not received minor. They are interim minor.
Lordship, I want to make my submission, Your Lordship.
No, I don't want to hear the submission because I have a meeting at 3:45, so I'm in a hurry.
Oh, only
So
one
if
thing,
suppose the updated case diary is not there,
Lordship, I am not on
we
that.
are extending your interest.
Lordship, that's correct, but I'm not on that, Your Lordship. My submission is, Lordship, that my client has informed me that, Your Lordship, on receipt of the bail, after granting bail before from the Honorable High Court, pursuant to the order, he did appear before the police station and got the statement recorded as well. But the thing is that, Your Lordship, as per the information derived, and time and again inform me that the police still they have been trying to harass my clients. So, despite having the bail, granting bail from this Honorable High Court, if the police disturbs us, even there is one lady is also there.
In the how it is, how.
I don't know,
you
Your
are
Lordship.
disturbed.
Yes.
But the question is that once you have appeared and your statement is recorded,
Yes.
may not be sufficient
My
for
lord.
the purpose of investigation. There may be something for which your presence, your further cooperation may be required. That may be one of the aspects why the police is searching for you or you're being asked to appear before the police.
That is also one of the
But I
conditions
don't
for
know.
bail.
But that is the condition itself in the bail matter. It's not that the case that within the 7 days you will appear once in the police station. That is not the case. As and when it is required. So I don't know. That may be the one of the reason why your petitioners were being called by the police station at the police station. That may be one of the reasons. And I don't know. To ask your client to just cooperate with the investigation.
I will
team.
cooperate and
Investigation
right from
team,
the very
because if some adverse report comes
Lordship,
against you, that may
Right.
be one of the ground for your rejection of the
Lordship,
bill
Lordship.
because cooperation if not be not there.
Lordship.
So we
Right
are
from the
calling for
right from the very inception, Your Lordship, I am cooperating, Your Lordship, and when required, as and when required, certainly I would appear before the police station, Your Lordship.
cooperate so that any adverse may not come
Right.
against you. Anyway, updated bill said not received. Should reminder. Yes, when it can
My
be
lord, 17/9. ma'am.
based on 17/9. Till then, if interim being extended. Your interim being extended.
Lordship.
22.
Here also, my lord, they are in interim, my lord, CD not received, my lord.
Lordship, this is the third occasion that the CD has not come since the month of May. There is interim, it may be made absolute based on.
But what is the reason?
My lord,
Because
my lord.
because though they are in interim, but
Minor.
still they are not on absolute
Yes.
pay. So still there is
My lord.
that thing.
If your Lordship may
So
kindly.
the intimate this one.
Okay, do you want
You interim also be
You are Mr. A.
Yes.
Yes, Amit.
Interim
Also for the petition, also have Mr. Bishop, Pilani, additional BP. Appearing on behalf of the submitted by Mr. Sharma. Senior receipt, on which it is submitted by Mr. Amit that it is the third occasion where the IO paid furnished the case diary. In view of this, the IO is hereby directed to furnish the case diary positively positively on or before the next date of listing. And the additional PP will also take necessary steps in this regard. List accordingly when it can be.
My
When
lord,
it
17/9, my lord. same.
Publish.
We're listing it on 79, your interim is extended,
My lord.
asking the IO to furnish this case
My
diary.
Publish.
That is your lordship.
Yes.
My lord, in this matter, my lord, on 23rd, 25, update case diary was called, and this honorable court repeatedly will not call case diary.
What is the position in?
My lord,
have
yes,
received the
Sarsit
case diary?
submitted.
Huh?
Sarsit submitted.
Oh, yes, sir.
Sarsit দিছে নেকি?
That's why it was taken back. Yeah, they were taken back for update.
Then, my lord,
Okay. Yeah, but you are not an interim.
No,
I'm not on interim, my lord. So, my lord, 15 days, my lord, time may be given for it.
No, not the case of interim, my lord. Case is also not.
You are at liberty to appear.
My lord.
Mr. PK declared cause of the petition. It is submitted by Mr. Sharma. That case has already been transited by CS number.
93 of 2025,
CS
Dated-
93 of 25,
dated 9/8/2025.
9/8. In view of this,
Right.
the petitioner is at liberty to approach the appropriate forum with an appropriate application, which may be considered.
Yes, my lord.
You are also appearing, na? Mr.
For
Karim?
informative,
Point.
AR Karim.
Yes, ARR Karim is a
Lordship, some observation, my lord, so on my appearance in your as per direction on my appearance. Some
cannot.
Lordship, some with the observation, so that I could appear, my lord. In fact, the case that filed, I appear before the court, my lord, with the since
What?
charge sheet has been filed, my lord.
Ah.
On my appearance, if I move the bail application, the as per law direction may be given to as per law my bail petition we consider.
No, that's what I'm saying.
Yes.
Passing the order
Yes.
that your petition may be considered
As per
in accordance with.
yes, my lord. Deep double. Yes, my lord.
Yes, what is the position here?
My lord, here charge sheet submitted, my lord.
You were on interim either?
Interim, my lord.
Yes,
Interim.
Then we are extending your interim. How many petitions are here?
Only one, my lord.
Only one, my lord.
Your
So,
interim was granted, I think, on 24/6.
Correct, correct.
We are extending your interim up to 15 days from date of order today. And with a direction to appear for regular bail before the strike. And what is the CS number?
Charge sheet number 109 of 25,
109 of 25,
dated 30/13/6,
30/36.
my lord. 2025.
Just we are extending your
Ma'am.
interim up to 15.
25.
Yes, what is your position?
My lord, here also charge sheet submitted, my lord.
My lord, the petitioner is on interim, my lord, and he is a government servant, my lord.
Interim?
So-
Interim, is it? Oh.
Yeah, correct.
He
He's a government servant, right?
yes,
So-
he is a sub-inspector in Assam policeman. So my only
So what is his allegation against him?
allegation is baseless, my lord, 69.
Oh, 69.
False promise to make.
Why it is this?
Why it is-
Baseless, my lord, we have annexed it, my lord. The document, why I'm saying it is a baseless allegation, my
But
lord.
otherwise, charge sheet submitted.
Sir, but 69 may not be
My-
baseless.
My lord,
May have
kindly
some
see
affair with
page
someone.
number 38.
Being a police officer, he can have an affair with someone.
Yes.
Not a bar, na?
Yes, but
May
there
not,
was no
may be
false
baseless, may
promise.
not be baseless. Anyway, you are on interim.
Yes.
Definitely, we are extending your interim.
Yes, only
up
prayer
to
is that
15 days. Yes.
can that interim be extended till his appears before sessions, man?
No, just try it once because it's a AB. Otherwise,
Yes.
also you are not behind the bar.
Yes.
So if suppose in any reason your bail petition suppose rejected by obviously by before the session only, it will be not before because it is
Right.
an anticipatory, I think. So it will be obviously before sessions.
Yes.
Maybe after commitment, may not be after committing. Also
Yes.
after committing the case, also you can appear because sorry, that will be
Yes.
15 days.
Actually, but what is happening is that the lower courts, by applying the judgment of Prahlad Bhatti,
Hmm.
the Supreme Court judgment is there,
Hmm.
which says that even in otherwise in sessions tribal offences, it is advisable for the magistrates to forward the prayer of bail of the accused persons to the Court of Sessions. Even
So
in
in
case,
that case, now it is forwarding on the basis of that
sometimes
judgment.
by quoting that judgment, these bail prayers are rejected also.
Why you can insist? I mean, you can pray
Yes.
for the court before the court so
Yes,
that
but-
it may be forwarded if that view is considered. Suppose
Yes.
Supreme Court view, then definitely it may be forwarded.
Yes, the only anxiety is that since he's a government servant and he's also an interim, so my lord, that
In that case, now at present too, we have no other option, but
Yes.
we are extending your interim up to 15 days.
yes,
But yes, obviously, if suppose in any case it is rejected or whatever, in that case we can call for the TCR and can produce your case diary because one thing is definitely will be there because you are on interim and you appeared before the
Yes,
High
yes.
Court with a prayer.
yes,
So that matter may be considered on your subsequent bail application if this petition is rejected by the but
yes.
not at this stage. That's what I'm saying. Not at this stage. You can appear. You can appear just with the thing, and if it is not
Then
suppose
my lord
forwarded or not.
Yes, then my lord will kindly extend the period, my lord, because he is currently in Dima Hasao district, my lord.
So what? Yeah. Otherwise, too, we are extending it for 15 days.
Yes.
Now, you want what period? 20 days?
20, yes,
20 days. We are extending it 20 days. for 20 days extended period. What is the CS number?
Charge number 152 of 25,
152/25,
dated 28/7.
2807.
Fine.
At this, we are extending your 20 days and see to it what happens.
26. Hello.
Yes,
Please, Your
26,
Lordship.
what is the progress?
Lordship, matter may pass on for the time being.
Time being, we're not going to sit.
Then matter may be taken another day. My senior is legs in code number
it should not
9.
be-
Madam,
you
here
have
we have
to
received
typically-
received the CD mallet, voluminous CD mallet. I have also gone through it, mallet. He was given the interim protection mallet, but from the mallet IO objection mallet, he has not appeared till today, mallet. He was directed to appear within 7 days, mallet, but he has not appeared before the IO mallet.
But you are not in a position to.
As per instruction of my senior lordship, he recently appeared before the IO.
When?
Last
Can you
2-3
tell us
days
just when?
ago. 2-3 days ago, maybe.
Even 2
Exact
days
date, I don't know. Then matter may be taken another day or after some time, my senior will appear.
No, time we cannot fill up,
Madam.
what I'm saying.
Then matter may be taken tomorrow or next week, any date.
But if suppose
Ma'am.
our client appears and his statement is already recorded, but it is not.
Not appeared, and
Then
there
in
also
that case, you do one thing. We may extend and her submission we may record here. Otherwise, you
then
can
we'll have
send
to
it back.
return back the CD.
Return back the inside. Because your statement is not available. That's why the IO's.
Not
option is
appeared,
also
but
there.
till 18th mallet. We have received case on 18th mallet.
18.
Day after yesterday, mallet.
Oh, then you have not appeared.
And they are directed to appear within 7 days, mallet, in the interim protection mallet. That itself is the violated mallet. He is not cooperating.
Yes.
That is the case.
So then what to do?
Petitioner said that he was appeared, lordship, but why is not recorded?
When he appeared?
The exact date, I don't know. My senior.
2 days before, then 18th mallet. Today is
Why
20
is not
mallet.
recorded? That's the question. Now, why is not recorded?
When
Where
appeared?
is it?
You see, when appeared?
Just tell us when appeared.
Mallet.
Exact date, I don't know. That's why
Actually not.
I'm taking time, lordship.
It is, we have received here, it is said that, my lord, during the investigation of the case, several sincere attempts were made to apprehend them, but they have managed to hide somewhere to evade the police arrest. That is, we have received on 18th, my lord.
Then one opportunity again given that.
We cannot list it tomorrow, but I don't.
My lord.
Let's see tomorrow or tomorrow too. It cannot be. Don't have. Day after tomorrow also there are some matters. কি করুন নাকি? হ্যাঁ হ্যাঁ
এতিয়া এপাৰেশ্যন খবৰ ল'ব লাগে, এতিয়া এপাৰেশ্যন এতিয়া হ'লেই নহ'ব নে, এসপ্তাহ সময় দিছে।
Senior তাতে কিয় হৈ তুমি কেনেকৈ শুনিছো। এতিয়া চাওঁ এতিয়া কিয় ৰেকৰ্ড কৰা এইটো গম নাপাই
এতিয়া হ'লেহে ৰেকৰ্ড কৰিব।
হ'ব নেক্সট ডে এতিয়া লৈ লওঁ না তেতিয়া বস্তুটো কৰি ল'ম।
You have already produced it is there. So we'll somehow we're listing it on by to 22nd.
Right.
Okay, 22nd.
Earlier in
22nd.
we can see.
Petition is demanded. 22. 8. CDB written.
27.
Earlier intimatum may be continued, lordship.
Yes, interim be continued till next.
Much obliged.
It's 27. What is the position?
Yes, yes, there is.
There is.
May I please, as your lordship, my lord may be pleased to find the FIR, my lord, is at page 15 of my petition, my lord. The pre-arrest bail application, my lord. I am not a named accused, my lord. My lord, may I read over the FIR, my lord? To the officer in charge of the Jorhat Sadar Police Station, District Jorhat, FIR against Gajanand, Gajju, Mundra and Non-Kishore Mundra for blackmailing, threatening, and extorting a massive sum of rupees 47 lakhs only, and again demanding a huge sum of money. With due respect, I would like to inform you that I am Sri Rajesh Kumar Agarwala, son of Mohabir Prasad Agarwala and a permanent inhabitant of the Radhia Babu Lane, Hati Road, Post Office, Jorhat, PH, Jorhat, District, Jorhat, Assam. So I would like to state that the said Gajanan, Gujju Mundra and Non-Kishore Mundra took shop on rent from the year of 2007. In and around the month of April 2022, Gajanan Gajju Mundra called me to his hostel, namely Rajmahal, situated at Gorali, Jorhat. Just pausing for a moment, my lord, may kindly note the date and year, my lord. It has been of 2022, my lord. Jorhat, firstly, it seems normal to me as I used to meet him at office to discuss any rental related matter. But after meeting with him, Gajanan Gajju Mundra showed me some pen drive and started threatening of dire consequences, as according to him, the pen drive contained the illicit video and audio clippings, which is out of my comprehension. At that period, my daughter was engaged and her marriage was due, so I got terrified. Taking advantage of that delicate situation of mine, both the brothers forced me to pay a huge amount of money, that is rupees 47 lakhs only, to them. When I did not had a cash with me, then even forced me to transfer all the money I had in bank account in the HDFC Bank to the RD Trading Company proprietors of the non-Kishore Mundra. The bank statement of those payment is attached with the FIR copy. That I also stated that for the marriage of my daughter, I was compelled to take money from friends and relatives on loan. Now they are threatening me for more money for the last 1 year. That recently, the GST department also required me about the his sum of money of rupees 47 lakhs on me in my name, reflecting in RD Trading's proprietors non-Kishore Mundra income tax returns. A photocopy of that IT return is also enclosed. That I have been duped all my old aged savings by these brothers and suffering mental trauma to the extent that I have lost all the hope. Again and again, I am contemplating to commit suicide, as I have no wish to live like this, sir. If I am made to commit suicide, these two persons, namely Gajanand Mundra and Non-Kishore Mundra, are the actual cause of my extreme step. Sir, I do want a legal justice from your competent authority, and it is therefore requested you to necessary legal action against and also take a proper legal action against both the accused persons, namely so and non-Kishore Mundra, for the greater interest of justice. So, my lord, this is a detailed FIR had been lodged, and in that FIR, my lord, not a single whisper of the present petitioner before my lordships, and who is in fact Parvez Hussain, my lord. Milord, he is no doubt, Milord, he is a very active social worker therein, Milord, of the Jorhat town. And what has happened, Milord, as per these two persons, the accused and the informant, are, Milord, a very old business connections were with them. So, Milord, therefore, there are certain transaction was supposed due with the, Milord, this Rajesh Kumar Agarwala is required to pay to this Gajanan Gaju Mundra and others. Now, accordingly, Milord, those transaction was done. It was a purely a banking transaction, Milord. So therefore, there is nothing to hide. Even, Milord, those transaction was successful also, Milord. It had been paid. Now, later on, Milord, as the terms and condition of those business dealings, or some discrepancies may be there with the parties. Therefore, Milord, this FIR had been lost. Now, Milord, when these persons, their disputes were going on, some of the parties, Milord, approached before me that if there can be any amicable settlement could be carried out through me or not, Milord. Then, Milord, I intervened and tried to amicably settle among the parties. Then, Milord, they somehow in some statement my name has been pronounced by some of the parties, Milord. What is in the case diary, I am not aware. But, Milord, they responding and in compliance with my lordship's direction, Milord, I have already appeared before the concerned police station. That is my instruction, Milord, and my statement had also been recorded. Now, what is in the case diary, Milord, that can be revealed my respected friend only, Milord. So, Milord, there is no involvement of the present petitioner with this sort of allegation, Milord. And being a social activist, Milord, I have been entangled. And secondly, Milord, this person has also approached before this honorable court the accused, and I have verified from the online, Milord. Their case is also pending, which I have also annexed in this petition. My lord can find it at page 23. This Gajanan Mundra's case And Sri Nand Kishore Mundra has also approached before my lordships for a pre-arrest bail, my lord. And now they are also with an interim protection, my lord. And this case was, my lord, taken up yesterday, I think, my lord, from the 19-8, my lord. But what is the order passed, my lord, that I am not sure, my lord.
Yes, my lord, I had received the case there. My lord, initially, my lord, from the FIR, it reflects that this is, my lord, a dispute between one Rajesh Sagarwala and Gajanan Mundra and Mundra. My lord, why these persons, my lord, name came to light? So, my lord, I have verified from the case diary, my lord. Now, my lord, in this case, one Gajanan Mundra against Gajanan Mundra, my lord, there he is already suspected accused in other two cases regarding that, my lord. There are Gajanan Mundra against Gajanan Mundra. There are other two cases. In those two cases, already suspected case, my lord. Name of the Gajanan. That is
Again,
one
Gajanan.
another. That is one another aspect, my lord. I will point out. But my lord, regarding that, actually that amount, this is from the investigation. It reveals that this is a case of, my lord, honey trapping. Regarding showing some video clips or audio clips, the allegation is that, my lord, all these amounts were, my lord, demanded, thereafter, my lord, taken away by these accused persons. And who is the present petitioner? My lord, he actually, in fact, along with one Riaz Hussain, my lord, your lordship may kindly tell this statement of one. Collection.
Collection.
One goes with everyone. No, no, I'll go take it. There are some other statements also there, Mani. That is the 164 statement of the complainant. Other statement also there, my lord.
What is this? Ezahar dear Dinakhan police said Parvez Hussainok Khanat Dhoriani. He was brought into police station. This fellow, this petitioner.
Yes.
Here it is written that Ezahar dear Dinakhan police said Parvez Hussainok Khanat Dhoriani. Our Thanar Mudiate, Riaz Hussaine, Ezaharpan, fellow Bolake.
Yes, Riaz Hussain was one of the associate of the Parvez Hussain. But as per the statement of the complainant that Riaz Hussain, my lord, threatened the informant that you withdraw the case against Parvez Hussain. Otherwise, we will take action against you. I, along with another 100.
There was a case against Parvez also. But
No.
this FIR is not against Parvez.
No. Because during investigation, my lord, because Parvez Hussain is the petitioner in this case, my lord.
Yes, but the FIR is not against Parvez.
FIR, my lord, Parvez Hussain's name is not there in the during your lordship, my first part of the, my lord, investigation, that is a detailed note of the investigation is there. First part trademark, my lord. Later on, my lord, at that point of time, by showing some video clips or audio clips, my lord, that is the, my lord, allegation of the complainant. That is the statement of the, my lord, 183 statement of the complainant.
But one aspect is there. If suppose it is a case of honey trap or illegal demand, say
Yes, yes, yes.
and as per the statement also, but why the banking transaction?
My lord, that is the debate because as per his earlier, yes, banking transaction is there because initially, my lord, one RD trading company is in the name of the one of the accused, Gajanan Mundra. As per his allegation, my lord, all these things comes to light after filing of this income tax return. Because while, my lord, GST department had this about this, all these 47 lakhs, my lord, question notice issued also to the informant. Why this, my lord?
Because yes, 47 transaction is that obviously GST department will make an inquiry, obviously.
Yes, and thereafter, my lord, now also, my lord, from the statement of the informant, since 2025 also, there is allegation that after, at that point of time, how they collected that amount regarding that, my lord, showing video clips, not only in a single time, my lord. Thereafter, my lord, occasionally from a particular month from the year 2022, all these amounts were paid by the informant to the firm of the, that is RD Trading of the Gajanan Mundra. And thereafter, my lord.
But the FIR, this money transaction was in the name of the said firm.
Yes, RD Trading Company of the Gajanan Mundra. And that account, my lord, is a, my lord, current bank account, which is, my lord, already, my lord, NPA, my lord, defaulted account. That account is made. So all that amount after making that payment, that amount adjusted against that loan account. Your lordship may kindly peruse once. That is the, my lord, regarding the material by the IO, my lord. That is first part of the case diary. That is flag mark. I have flag mark. Here it seems that yes, this is a case of 2022, and in the year 2005, this FIR has been lodged.
25. FIR closed on 25.
25 years. So during investigation, these materials are in the case diary for which I pointed out to the lordship. And regarding Gajanan Mundra, in 2 other cases, he substituted.
So this kind of demand and all is going on since 2020.
My lord, the transaction, my lord, which was occurred as per the FIR in the year 2022. My lord, had there been a case of honey trapping, any human being, my lord, with a, my lord, instinct, he will immediately approach before the police station. Immediately, my lord. Now, this informant waited for more than 3 years, my lord. My lord, what has happened when the GST authorities has issued the notices, my lord, only to cover up these notices, he has make up this story, my lord. That is my instruction. My lord, there is the video clipping or something like that. Now the police has already investigated whether any such pen drive or video clipping that has been, my lord, seized or collected or sent for the forensic examination. That is, I don't know, my lord, is a part of the case diary or not, those things, my lord.
Yes, in that case.
My lord.
Because main allegation is
Yes,
showing one pen drive.
One pen drive, my lord.
So that there are some, maybe some objectionable video and all for the honey trap.
Yes, yes.
My lord.
Because otherwise there is no other allegation that any woman was there, he was brought to that woman. This kind of allegation is not only showing a pen drive. Those demands were made.
My lord.
But the question is just pen drive is there or not? Whether it is seized.
Pen drive regarding that aspect, my lord, I have.
That is a main vital evidence.
Why
my
these
lord.
persons approached before this honorable court for anticipatory bail?
More.
Yes, well, because my lord,
yes.
on the pretext of settlement, if some dispute occurred, my lord, after that, my lord, your lordship may kindly peruse first portion of the, my lord, case.
IO's note.
Yes, yes,
IO's note.
yes, yes. That regarding some investigation that being a social worker or maybe a student, whether I don't know, my lord.
The move notice to this.
Yes, notice issued.
My lord, because I have
So,
been served with a
and
notice
regarding
to
that
appear.
aspect, there is also well, a statement of the complainant and his wife that he demanded well, additionally an amount of rupees 10 lakhs.
Any allegations
is
can be brought on.
The statement of the witness. And my lord, he appeared, my lord, our statement is there.
My lord, whatever is there, my lord, I will cooperating with the investigation, and in future also I am duty bound to cooperate, my lord. That
There
I.
also one page that
Why?
during the time of investigation, the bank statement records of the prime accused Gajanan Mundra corroborated with the bank statement of the middleman Parvez Hussain, and it has come to the light that Gajanan Mundra transferred money. There was transfer of money also
Yes.
during the time of trapping.
Somehow, my lord, this petitioner is involved. My lord,
Thereafter,
how?
again, it is also stated that they were acted as a middleman.
Yes.
But even if middleman then again started demanding money.
Yes. Because for settlement or for somehow he demanded money. My lord. That is the.
No, my lord, my bank statement has never been asked by the police, my lord, or where from the copy of the bank statement is a part of the CD or not. I don't know.
During further investigation, everything
My lord.
will come out. My lord, let him, my lord,
I'm, my lord, even after the bail order, my lord, after my appearance, 2 times I have been summoned, my lord. And then also I visited the police station, my lord, for the purpose of
2 times someone means prior. to
some,
this
my
order.
lord, they have the, IO has, my lord, called me upon for certain queries and questions, my lord, when I also cooperated with them, my lord. That is my instruction, my lord. And I am a very, my lord, active social worker of the said area, my lord. A known person, my lord, I will not violate any terms and conditions, my lord, if imposed by my lordships, my lord. Custodial interrogation for me, my lord, may not be required.
Sushil, the initially well, interim granted at that point of time, it is mentioned by your lordship that in that order submission.
No,
in
that is correct, but my lord,
Yes,
that
my
is
lord.
my submission has been wrongly recorded as a, my lord, ASU leader. I have submitted before my lord, it is my mistake, my lord. But actually, he is a social worker, my lord. That miss, for that, I also come up with an IA.
Yes, yes, I
My lordship can remember, but later on, my lord, we have withdrawn that IA, my lord. So that is not a big issue, my lord, but I am a known face of that Jorhat town, my lord. Everybody knows me, my lord.
Are you a local dada there? No.
No, my lord. Nowadays, my lord, it is very difficult to being a dada, my lord. This administration is very strict, my lord.
It will come out well, during further investigation.
Mr. A.R. Priya, Ilan Mr. P. Waterford, Ilan This is an application in section of Likilogo, yes. CD receipt, belt receipt. Help area. It is submitted by Mr. Priya, Ilan Council for Repetition, that the present dictionary is innocent, and he is no way connected to the instruments. However, he received after obtaining the order of interim pre-arrest bail, he appeared before the IO and cooperated in the investigation of this case. Before obtaining the order of interim pre-arrest bail also, he appeared before the IO and received a notice issued on him under section 553 AICC. He further submitted that there was a business transaction between the informant and the prime accused Gazanan Mundra, and only for the said business transaction, there was a monetary transaction of around 47 lakhs towards which was deposited towards the bank account in the name of this RD Tradings of the prime accused. The present petitioner was only a present petitioner, who is also working as a social activist, only interfered in the for settlement between the informant and the victim. But for that, only for that reason, he was asked to appear before the police station. Accordingly, he cooperated in the investigation. He further submitted that the petitioner is still ready and willing to cooperate with the IO in further investigation of this case if he is granted with the privilege of pre-arrest. Next paragraph. Mr. Pautaku, the learned additional PP submitted in this report that there is no such business transaction, and basically it is a case of money trapping, wherein the informant was rupees 40 lakhs was demanded by showing some video clips, and in the name of settlement, the present petitioner along with one Riyaz Ahmed also demanded money. However, it is the fact that all the transactions were all the monetary transactions were through bank and the money was deposited in the account of RD Trading, the company of the prime accused Gozendra Gundra. However, Mr. Botakur submitted that the present petitioner appeared before the IO after obtaining the order of interim pre-arrest bail, and his statement is accordingly recorded. If further submitted, that his further cooperation will be needed by the I in the interest of the investigation, and accordingly, he may be directed here before the I as and when his cooperation will be required. Next, getting the submission made by Learning Council officers and prepared the case diary, the note given by the I along with the case. Considering all the materials available in case diary, submission made by Learning Council would find that I find it a fitness to extend the privilege of pre-arrest bail to the present petitioner. However, the direction to appear before the investigating officer as and when his presence is required. This cooperation is required. Accordingly, the order of interim pre-arrest bail dated 19/07/2025 is hereby made absolute with the same terms.
My lord, deeply obliged. Before. Hello, CD was called for, and as per direction of this, I also appeared before Dayu, and my statement has been recorded.
My lord, CD received, my lord. And after entering, he has appeared, my lord, statement recorded, my lord.
FIR is page 9, my lord. Manual is page 11.
FIR is that page?
Page 11. Wait.
That lottery tickets were
My lord. Actually, I am not involved. The person who involved, his phone number is here. And he was arrested in.
These are not your phone number.
No, my. That person was arrested, and subsequently he was released on bail by reasonable court. I am a student. I am his friend. My mobile phone was kept by the IO for further investigation. I will cooperate in my lord.
So he used to sell the lottery tickets, but here he's not aware regarding the this Offcom Bottora number Facebook post. But he is not admitting that those two mobile numbers true. Those posts
My
were
lord, it
there.
is this is the statement of the accused arrested, my lord. Arrested accused person, my lord. His statement is also the
Here his name is, your present petitioner's name is?
Azizur Rahman.
Azizur Rahman is the petitioner here.
It is the co-accused statement, my lord.
So he is the mastermind.
And he was released on bail by reasonable court. He was arrested. That
interim granted.
No. Azizur Rahman is interim, but other person who was granted bail by them. Okay, now? Mansur Mansurul Haq.
And
He was released on bail
his
after
present
arrest.
petitioner statement is where it
There in the past.
Police statement.
His statement is a complete opposite, man.
and they are giving this separate different statement.
Here he is.
And in whether this mobile phone, etc., those were seized?
My
Seized or not?
See, my lord, there is my lord,
The mobile number, my lord, bearing number 6001, he was arrested.
Who is he?
He is in Mansudul. He was arrested. And my phone number, police says, while I appear before IO, police also kept my phone. But my phone number is nowhere mentioned here.
There is an objection, my lord, in the funds. Yes. Initially, my lord, bill objection. Here it is mentioned, my lord.
So I am a student, my lord, and he is my neighbor. It is correct. That Maksudul is my neighbor. Well, I will cooperating with IO, my lord. My phone number already says, my lord. And offense has not committed. It is mentioned in the FIR that tried to collect money by using the name of the club.
So implementing digital evidence was removed, recovered during images, fake lottery tickets, etc. QR codes used in the for online transactions. So he is the mastermind.
He is the, although he denies his allegation, my lord, in his statement, my lord. But from the statement of the arrested, my lord, accused person, he is the person.
So I am a student, it is second year student, my lord. Page 8, my lord.
That's why too you are sharp.
Yes.
You are sharp.
Well, any condition I will cooperate for further investigation, my lord. My phone has already been seized. I will already appear, my lord. I am a student, my lord. And I have been falsely implicated. This person, he is my neighbor.
But Mr. G. Ahmed, the learned counsel for a petition. Also heard Mr. B. Sharma, the learned excellent PP, appearing on behalf. This is an application under section so and so in connection with so and so. His records, CD receipt. It is submitted by Mr. Amit, the learned counsel for the petition, that he is innocent and will be eligible. He further submitted that two mobile numbers which were given in the FIR also does not belong to him. And however, as belong to him, he is a student of third semester BA. And without his any sort of involvement, police is searching for him and for which he can appear before this court with a prayer for interceptory paper. However, after obtaining the order of interim pre-arrest bail dated 19/07/2025, he appeared before the I, cooperated in investigation, and his statement is also recorded during investigation. Apart from that, his mobile handset were also seized by police. He is still ready and willing to extend his cooperation in the further investigation of this case if he is granted with the privilege of pre-arrest. Next one, Mr. Sharma, the learned additional PP, submitted in this that present accused petitioner is the mastermind of the entire crime, and he is the person who used to sell the tickets through online and was and engaged the other co-accused person to sell the lottery tickets. On examination of the accused mobile, sufficient incriminating digital evidence were also recovered by police during investigation. Accordingly, Mr. Sharma submitted that it is not effective to extend the privilege of pre-arrest bail to the present petition, and this custodial interrogation may be required for the purpose of investigation. Next paragraph. Hearing this submission made by learned counsel, I have also filled his diary and the note given by the It is admitted fact that after obtaining the order of interim pre-arrest bail, the accused appeared before the IO and his statement is also recorded. However, from the uh, materials available in the case diary, it's seen that he is the prime accused or the mastermind who used the Facebook post titled Appam Batora, AXOM, Appam Batora, to advertise the scheme. And on examination of his mobile also, incriminating digital evidence was recovered, including the images of fake lottery tickets. He also used QR codes for online transactions. Thus, it is seen the present petitioner is the prime accused of the entire crime, who engaged the other accused persons in stealing those tickets through online and offline mode. Considering all the above,
He's a student, but-
considering all the above circumstances of this case, nature of offense alleged to have been committed by the present accused petitioner, I find that his custodial interrogation may be required for the purpose of investigation, and accordingly, I do not find it effective to extend the privilege of pre-arrest bail to the present petition, and hence the order of interim pre-arrest bail dated 19/7/2025 is 20/7/2025 stands packeted, and the present petition accordingly stands rejected. Your petition stands rejected. The earlier interim petition is stands packeted. You are the mastermind.
Hello, Lajit. He's a student, my lord.
Yes, it's obvious. That's why you were sharp. Yes, what about the 29?
We have received the case there, my lord, but FSL report not received here, my lord. Cause of death is pending, my lord.
Although
My lord, it's he's committed a suicide, my lord. On earlier occasion, your lordship he has taken a loan from me of tune of 11 lakhs, my lord. Now, the
You
FIR.
admitted that the loan was taken and you also demanded the money. That is
Yes, sir, that is the thing. I demanded the money, my lord, and he committed suicide. What I get to know, he has taken a lot of money from different person, my lord.
My lord, here is a long suicide note, my lord,
Huh?
alleging the my lord.
My lord.
Then do one thing. You need the FSL.
Oh, my lord, that is cause of death, my lord. He was found in the my lord, river, my lord.
Found?
River, my lord.
Bank of the
Bank of the Brahmaputra River in Dibrugarh, my lord.
Oh yes, yes.
And
when
he has given left a suicide note and implementing us that because of the mental torture by me regarding demanding of money, I committed a suicide. So immediately, my lord, he has taken 15 lakhs, 11 lakhs from me, 6 lakhs. That is on record, my lord. 6 and 5. Definitely, when I give a money to somebody else, definitely I ask the money because my wife has gone for a medical treatment, which I cannot give the treatment because the money I have to go to money, my lord. So my lord, asked them repeatedly. He said, I'll give so and so. Then before, my lord, what you call, my lord, his committed suicide, my lord, he issued a check, my lord, which I also annexed the check.
Yes, yes.
The
I
check,
can understand.
my lord, to the tune of, my lord, 6 lakhs. My lord.
Due to some
My lord.
time constraint, you have paucity of time most probably. We'll do one thing. Your interim we extend. We are
My lord.
going to extend your
My lord,
interim.
my lord.
In the meantime, you collect the FSL report. CD may be returned because it may come along
will
with
take
the
time,
CD.
my lord, my lord.
That
My
will
lord,
be
yes, my lord. I have also appeared, my lord. My statement also was also recorded, my lord.
Part Mr. P. Bora, the learned senior advocate, assisted by
H.K. Sharma.
Mr. H.K. Sharma, the counsel for the petition, and also heard Mr. P. Sharma, the learned additional PD appearing on behalf. CD received, however, it is submitted by Mr. Sharma that FSL report is not yet received, for which cause of death not be ascertained until date. In view of this, let the updated case diary be called for along with FSL report. If already collected by the IO, please the matter, yes, but can be listed. 11, 9, 10, can
My lord, 19 September.
19 September.
My lord.
19, 9. list the matter for 99, interim be extended till next year. আপনি ধরিব পাৰিছে এটা মোৰ বিকে Okay.
I'm obliged.
City.
Negligent lordship. For 82 bail application, CD was called for.
You have received the case diary here?
My lord, CD not received, my lord. Here also serviceable, no? Poxon.
Poxon.
My lord, Poxon is there, my lord.
Oh.
First it will go to appropriate date.
আহি যায় হয়।
Get an Poxon. Second time.
What is the
This is earlier rejected.
Earlier rejected. This is the second time bail application.
No, it's okay, but service not yet received, you can make a inquiry regarding the service. If service is already there, then we can appoint an amicus also.
Right.
On the last occasion, actually, you were directed to receive instruction. Is there any instruction? Have you received any instructions? Seeking permission to leave the jurisdiction of CGM Kamruk M for 10 times, till date for 10 times, as he is a resident of Bilaspur, Chhattisgarh, wherein he also has his business establishment. Mr. Mitra further submitted that FIR of this case was lodged on 11/6/2022. But even after lapse of more than 3 years, the charge sheet has not been filed in the present case. However, he is ready and willing to extend his cooperation in the further investigation of the case if his presence is required in further investigation. Full stop. But till date, the IO did not call for. But till date, the IO has not called for the present petitioner to appear before the police station. However, he is ready to appear as and when it is required. Mr. Portapur submitted that they said bail condition may be altered or modified with a direction to surrender his mobile phone number and other documents for his identification before the concerned police, before the IU, concerned IU, and also may be directed to appear before the IU as and when it is required for the purpose of investigation. Next, considering this submission made by non-constitutional persons, the present interlocutory petition is allowed, and accordingly, the bail condition of 6(a) passed in bail application number 2072/2003 dated 22/06/2023 is modified to the extent that petitioner shall and petitioner shall give the phone details and the identity card, Aadhaar card, PAN card, copy of the identity card, Aadhaar card, PAN card, etc. before the investigating officer, and will also cooperate in the investigation and also cooperate and will also appear before the investigating officer as and when his presence is required.
My lord,
Let's
can I submit my documents before the learned CGM, because the IO I think is transferred and currently I don't know who the IO
Okay,
is.
CGM to proceed.
My lord.
CGM to reply to 6(a) to invert comma reply modified terms to okay.
My lord, just another issue, my lord. Out of the same FIR, another co-accused is there who has a similar prayer that is listed in my lord court number 24. So my lord, since this order was passed by Justice Malashi Nandi and she's there no more, lordship is taking up the matter. Now since lordship has passed an order, so perhaps my lord will have to also take that.
How can I say?
No,
It was a
initially,
notification, my lord.
So I cannot.
he should have pointed out, my lord, initially, my lord.
This matter is not listed, it is listed
Yes.
today.
Yes, my lord. Today only it's listed. I had filed,
Today only where listed?
my lord, in court number 24.
That Then how can I say? As I'm passing the
My
order,
lord, my
that court also may pass the order because the order passed by Justice Dandi, she is not here.
My lord,
So that can be, you can make a prayer.
my lord.
Okay.
God bless.
Relax.